Item 44, Lordship. I have some personal difficulties with it. So you may kindly adjourn the matter for
Mr.
P.P. Waterco.
P.P. Thakur and counsel for the petitioner who prays for an adjournment with the consent of the item number 44
Yes. Respondent number 2 is there.
with the consent of the other side. Considering the fact that the respondent side has not opposed the prayer of the prayer is allowed. Let this matter be
5th of December, Lordship.
no fixed after a week.
Any date, Lordship, 12, Lord. 12 December.
If December is it possible,
12.
let this matter be listed up on 12th of December.
You may please, Your Lordship. The regular application filed on yesterday. The case is already numbered and registered. My Lord, this is a similar case. The Sunmoni Rava case was granted 1222, the accused person. If you will allow me to move this to bail application today, my Lord.
Let it come up.
Okay. Hold on.
My please, Your Lord. So she is the 439 application, Your Lord. So my prayer for listing for motion, Your Lord. May kindly be on Monday, Your Lord.
Monday holiday.
Oh, it is there. Amlaji.
May I please, Your Lordship? Lordship, I am from item number 29. Lordship, the name of the CPI is not shown in the cause list. We request for the right registry may be directed to show the name in of CPI in the cause list. We will also serve a copy to this
Item 20.
29.
We'll pass orders when it is called. When the item is called, then we'll pass orders.
Next week.
No, we are not passing orders.
Okay. Now, please, Your Lordship. Item number 14, Lordship. Earlier two occasions, Lordship, the matter was not reached. Can it taken up at two, Lordship?
34.
No, you have to wait for the item number 14.
One for
It will reach today.
Oblige.
May I please, Your Lordship? My Lord, one minute period bail application, my Lord. One lady is there, my Lord, petitioner, my Lord. Along with others, my Lord. She is suffering from serious illness. Kindly, my Lord, to bail. Already numbered. Signed on 21.
Prayer is
One lady also is
on
there.
Monday, on Tuesday.
May I please, Your Lordship, I beg to mention item number 39. It is not happen at
Is there not?
Heard Mr.
10.
N.Uddin, learned counsel for the petitioner, also heard Mr. R.J. Borwa, learned additional public prosecutor, who prays for another date for producing the case. That prayer is allowed. Let this
8-12.
case be listed on 8th of December. The interim order shall continue.
My Lord, I beg to matter item number 42. CD has not come. So matter may be released on after 1 week.
Heard Mr.
Yes.
A.S. Ali, learned counsel for the petitioner, also heard Mr. R.J. Borwa,
40.
who prays for another date for producing the case. Prayer is allowed. Let this matter be
7th.
listed on 7th of December. But the interim, are you on interim? 7th of December.
Please, Lordship. Lordship, I file in the earlier Lordship for modification of the order dated 21/11/2023. Lordship, matter may be listed on the Tuesday, Lordship.
May I please, Your Lordship? I beg to mention item 24. Lordship, CD was called, but today the CD has not arrived. Lordship, there is urgency in this case because I have cleared the APSC mains exam and I have my interview in the month of December. It may be listed on Wednesday if possible.
When city can be. Heard Mr. What
G
is
got
E code? Item number 24.
20.
E code Sheikh Lalit counsel for the petitioner. Also heard Mr. R.J. Borwa, who praise for another date for putting it. Let this matter be listed on
on 29.
29th of November. Okay.
Yeah, the document item 55. The matter will be taken at the last item, my lord. It's admission column, my lord. It will take only 1 minute.
Yes, yes, sir.
Only LCR may be called for, my lord, and the matter will be admitted. The last item, kind. Item 55. Some supplementary admission
Item number 55.
before I think the last.
Supplementary discount.
It will take
Okay.
only 1 minute. Give you the
Start.
Motion BA item number 1,
Delivery.
delivery and purchase item number 53.
Into record to ভিতৰত dictation there. The for reasons mentioned in the order, the criminal petition is allowed and the impugn order is better.
Simply right. Now, in respect of one, another item, item of 57 of the supplementary list. In the query that whether the second application is entity. Is numbered, it can be entity.
No, we'll take it up when it is called.
Because I have to, if certain problem is there. Not argument.
Then we'll give a short date
Lock to be kept.
because I may have some query.
Yes. That
We'll-
query has to be answered here.
So you may not be there when it we are adjourning this matter for today on your request.
On 20,
On request of Mr. R.P. Hajit, Cabinet Council for the petitioner, this item number 50.
57,
This
supplement
matter is adjourned for today. Let this matter be discussed on
20,
20,
Eight.
28,
I will answer.
20, 29, 11.
29. So, deeply applied. Deeply applied.
Visuddhi.
Yes, sir.
My lord. My lord, this is put in an application arising out of a Hattigaon PS. And the allegation is suspected counterfeit currency, dealing in suspected counterfeit currency. Had been in the FIR is at page 8, my lord. The type copy.
Since when you are detained,
41 days.
yes, Mr. Burra, whether CD would be required.
My lord, yes, it will be required.
Let us call for the kidnap. Third, Mr. R. Sharma, the senior counsel, assisted by.
Yeah.
Yeah, Ahmed, the counsel for the petition. Considering the nature of allegation leveled against the present petitioner in the FIR, perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary fixing
3011.
3011 for case.
My lord, I beg to state that in the prayer portion on page 10, there's an inadvertent error. Instead of 489 C, we had put 489 B. My lord, that may be allowed to be corrected. Just a small inadvertent error. It should read as 489 C, not B. That is a typographical.
Learned senior counsel for the petitioner submits that there is an inadvertent typographical error in the prayer portion of the petition and seeks to make necessary correction. Where is that? You have to seek correction. You have to do the correction as per the rules prevail.
Similar order arising under the same code. Same date,
Same order, same
Yeah.
date, same CD,
same thing,
same CD,
Same.
same order.
and same correct. Okay.
Then you have to do correction, not by hand,
My lord, I am
same order.
obliged.
Mr. Kindly call for the case diary because my though I'm not naming the FIR, my lord. It's the allegation of gang rape.
Heard Mr. FKR Ahmed, learned counsel for the petitioner. Also heard Mr. R.J. Purvalan, additional prosecutor. Perusal of the case diary would be necessary for consideration of the instant bail application. It's called for the case diary.
412.
412.
Item number 4.
Your Worship, 439, idea rejection, and that we can just stage, my lord. Already that's my lord, now 50, today is about 60 days, my
What is the offense?
376 basically, your word. After close the city, your lordship rejected, I have come only, my lord, at this stage, my lord. 59 days, city, of course, my lord, I do not know whether it will be
57
required or
days.
not, my lord.
57 days.
But
So
on the
progress of investigation and
Well,
period.
That I have to take instruction notice whether it's completed or not.
Yes.
Mother, he already put on a suspension, is number one. Number two,
No, but case diary would be required
Yes.
for
only, my lord, anyway, 439, only third date, my lord, if possible.
On my lord 20, my lord 8. On 28, my lord, next month, Tuesday.
how many days you have been.
58 days by 57 days.
57 days.
57.
You may take some more days
Yes, Lord, we
but
can-
to ensure that case diary
Yes.
arrives. Because unless case diary arrives,
That's two.
Well,
second-
let it be on 30, Lord. 30, 11.
you will be able to bring
Yes, why don't you- here, my lord.
out Mr. H.R.A. Chaudhary, learned senior counsel, assisted by Mr. M.I. Hussain, learned counsel. Heard Mr. R.J. Purva. Considering the fact that this bail application is moved by the petitioner for the second time when after rejection of his prayer for bail on an earlier instance, perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary. Fixing
30, 11.
29, हो गया, 29.
Just
Possible
29.
30 I have time. 13. Yes, plus 30.
30,
Easy.
30,
11.
May please, Your Lordship. This is charge sheet item,
charge sheeted case.
charge sheet case.
What is your submission?
My submission is
Yes,
kindly call
Mr.
for
Borwa.
LCR. Kindly call for LCR.
The LTR will be required necessary, Lord.
Heard Mr.
I'm Rahul.
M. Rahman, learned counsel for the petitioner.
Lordship,
Also
may kindly be given short date.
Mr. R.J. Purva, learned additional public prosecutor. Perusal of the scanned copy of the LCR of GR case number 181/2008, along with the case diary of Pokajan PS case number 50/2008 would be necessary for consideration of the instant bail application. Hence, call for the same. Fixing
Anyway, Lord, it has to be called for today's date.
4th December, may can
4th. Fixing 4th of December.
Lord, scan copy, mother,
The-
along with
the-
etc. report of the case.
The fourth. Fixing 11 December.
5th or 6th, we can. Actually, my mom has expired, mother has expired on
Let it
16th.
be on 6th of December. 6th of December. For registry shall take steps for requisitioning the scanned copy of the records.
Okay. May I please the court? Lord, this is 439. Lord. This was a charge sheet,
Charge sheet.
Lord. But I would take a lot to annex 3, page number 22. Because the police state is nothing not showing the petitioner absconded. And when he received the summons, he also entered appearance. But for some reasons, he could not appear for few dates, Accordingly, non-available warrant of arrest was issued. And the petitioner approached this honorable court by a criminal petition, and that was allowed, thereby setting aside the warrant of arrest. So when he appeared before the landed court below, my lord, as per the direction of this honorable court, he was put behind the bar.
Where is the order?
That order your lordship will find at page number 20. Annexure 3.
What is the punishment?
Section is, my lord, 302,
302.
my lord.
Yes, Mr. Purva.
I'm sorry, my lord. 364 and 365. I'm actually 364 and 365. I think.
It is not 365, 395.
So my lord, 364 and 365 probably, Lordship. Yes,
But-
my lord, annexure 22, Lordship. It has been registered, my lord.
But in fact, my lord, of course,
There's a mistake in the order also.
yes. But it would be 395 only.
It
will be
has to be
395.
395.
95.
What is your submission?
My submission, my lord, otherwise if he has, my lord, appeared before the court, Lordship. Face the trial.
I'll appear, my lord, and I'll cooperate.
Mr.
Yeah.
A. Ali, learned counsel for the petitioner. Also heard Mr. R. J. Barwa, learned additional for the prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, Mr. Khairul Amin alias June, who has been detained behind the bar since 27/10/2023. Stop. Learned counsel for the petitioner has submitted that against that. Where is the affair?
FIR, your lordship will find at page number 11, my lord.
That on the basis of an affair filed by one Manoranjan Singh on 13/10/2019 before the officer in charge of Pathshala Police Outpost, before the in charge of Pathshala Police Outpost under Patasar Kushi Police Station. An investigation was started, and after completion of the investigation, charge sheet was laid on 14/10 on 8/11/2021 against whom charge sheet has been laid?
Charge sheet has been laid as many as, my lord. There are 5 PD. Your lordship will find at page number 18, my lord.
Against five accused persons,
Including the present petitioner.
including the present petitioner, showing the present petitioner as an absconder. It is further submitted that the committal court, after receipt of the charge sheet, had issued non-bailable warrant of arrest
Initially,
against
summons were issued.
then
Initially, summons were issued. He appeared, but subsequently he could not appear. Thereafter, my lord. Warrant.
that initially when you appeared, you were allowed to go on bail.
No, my lord, because I could not procure the bail. That is, therefore, he sought for some time. But subsequently, he did not appear.
So
Therefore, and will
pursuant to summons, you did not appear.
I appeared from my engaged counsel.
You personally failed.
No,
to-
no, yes.
Initially, the committal court issued summons to the present petitioner However, as he could not arrange bailer,
Yeah.
he could not appear before the committal court personally and engaged a counsel. The committal court did not accept the prayer of the petitioner at that time and issued non-bailable warrant of arrest against the present petitioner. Stop. It is further submitted by learned counsel for the petitioner against the said warrant of arrest. Against the issuance of warrant of arrest, the present petitioner had earlier preferred a criminal petition before this court, and this court by
Order
order
dated 13/10/2020.
13/10/2023 quashed the
Warrant of
this court by 13/10/2023 set aside the order of issuing warrant, order of the learned committal court by which the warrant of arrest was issued against the petitioner. Thereafter, the present petitioner on
27/10.
27/10/2023 appeared before the learned committal court. However, as one of the offense in what is the punishment
Life. Imprisonment for life.
as the offense involved in the case entails punishment for life, learned committal court rejected the prayer for bail of the present petitioner and remanded him to custody. Learned counsel for the petitioner submits that he is ready to face trial, and as the investigation has been completed and there is no necessity of keeping the present petitioner behind the bar during the pendency of the trial. Learned additional public prosecutor also fairly submits that if the petitioner is willing, if the petitioner cooperates in his trial, his custodial detention may not be justified. Considering the submissions made by learned counsel as well as facts of this case, the present petitioner, namely Khairul Amin alias June, is hereby allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned, which is the committal court,
Committal court is not
learned judicial magistrate first class Bojali, where the case is pending.
before the judicial magistrate.
Judicial magistrate first class Bojali,
First.
before whom the PRC case 447/2021 is pending. With above observation, this bail application hereby.
No, only my lord, our this honorable court, my lord, earlier Captain Evans, my lord, warrant of arrest.
Instead of setting
That
aside,
may
instead
be
of setting aside earlier,
Captain Evans.
the warrant of arrest against the present petitioner was kept in abeyance.
Pressure under 376.
Case diary would be required.
My lord.
Heard Mr. P. Hajorika, learned counsel for the petitioner, also heard Mr. R.J. Borwa, learned additional public prosecutor. Let the case diary be called for fixing.
No, Hazur case, we can fix it on the 4th December.
Fixing 4th of December for case diary.
It is Bora.
Sorry, instead of P. Hajorika,
It is Bora.
name of the counsel is H.S. Bora.
Okay.
4th. Right. Next, please, your lord.
The petitioner was arrested on 10/10/2023. Allegation was attempt to rape man. In fact, it is counter block affair.
Case diary would be required.
My lord.
Yes.
Heard Mr. N. Uddin, learned counsel for the petitioner. Also heard Mr. R.J. Borwa, learned additional public prosecutor. Let the case diary be called for
8/12
812 for
Number 9.
May I please your lordship? Put 13 application, my lord, petitioner arrested on 13, my lord, on the 13 days, my lord, the FR, my lord, and it is the FIR at page 9, my lord.
on when you were arrested? 13? Date of arrest is?
Date of arrest, my lord, 13/11/2020. 13/11. Page
Oh, what
9,
is the offense?
my lord. My lord, page 9, my lord. May I read, my lord?
No, why? Whether case diary would be required? Mr. Barua.
My lord,
My lord, pro FIR is there, my lord. Is the annexer 3 page.
Why
14.
your prayer was rejected by the court below?
No, my lord.
You,
Page 15, my lord.
you have not approached
Right.
any court.
No, my lord, no. My lord, here, my
it
lord.
is the FIR and makes lordship, section 326 is there.
326 is
My-
there.
My lord, here, my lord, under the instruction of the wife of the accused number 1, my lord, but wife was not implicated in this case, my lord.
We have to peruse the case.
Right.
Heard Mr. R. Ali, learned counsel for the petitioner. Also heard Mr. R. J. Barua, learned additional public prosecutor. Considering the nature of allegations leveled against the present petitioner in the FIR, the perusal of case diary would be necessary. Hence, call for the case diary. Fixing
812.
8 for case.
Oblige.
Item number
May I please your lord. FIR, your lordship will find at page 9, my lord. The allegation involves 392 and 99. I think case diary may be called for.
Heard Mr. S.
Alim.
S. Alim, learned counsel for the petitioner. Also heard Mr. R. J. Barua, learned additional public prosecutor. Call for the case diary. Fixing
612.
612 for case.
Oblige, my lord.
for motion item number 11.
No, this is a transfer petition, my lord. The petitioner is the husband and the respondent is the wife, my lord. What happened in this case, my lord? The wife respondent has filed a 125 CRPC petition before the Court of Principal Judge Family Court at Guwahati, my lord.
Okay.
Now, my contention is that, my lord, both the petitioner and the respondent are from Hosai. Now, she has misrepresented her residential address, used the address of her relative, and then filed this case. And we have also the petitioner filed a restoration of conjugal rights, and it has been decreed ex parte in favor of the petition. My lord, I would just like to take you through page number 54, my lord. It will prove that they have a child, they have an issue, 7 years old, and he is studying in Hosai, my lord,
With whom the child is?
with mother. With mother. There is a in the interim order,
This
my lord.
is a maintenance application.
This is the maintenance.
At what stage it is pending?
We have filed a WS.
You have appeared.
I have appeared. We have filed a WS. There is an interim order, which is at page number 46, my lord.
No, let us issue notice to the.
My lord. But in the meantime, my lord, the proceeding before the trial court may be stayed, my lord.
No, how we can stay maintenance proceeding without hearing the.
But till the next.
Item number
There's an application under section 397/401 matter against the findings passed by Learned Session Judge in a criminal appeal number 41/4/2019, upholding the conviction of the appellant. This petition under section 354/444 448 IPC might passed by the magistrate, imprisoning me, sentencing him to undergo 3 months imprisonment and a
1
fine of
year.
rupees 1,000.
No, 1 year is the maximum, Niki, Kibata? 1 year under 354.
and 1 year for 354. Now, basically, what happened, my lord, initially the case was filed, registered under section 354B, man. And I was charged under 354B and trial was continued, man. But however, what has happened, my lord? 350, without any reasons, my lord, though I should have been acquitted of 354B, but court has convicted me under 350. Because what has happened, the clothes, because there was no evidence that I have this clothes, the prosecuted. And moreover, the husband, the other witnesses, independent witnesses, that I was brought to the house of the informant, my lord, by her husband for payment of money, and there was a fight between the husband and his wife, along with me. That is another version. The two versions are there. And
Let the LCR from Lordship
so
here.
there were many discrepancies in this case, my lord. The 354B and 350 are totally different. Outraging of mercy, that is a disglory. They cannot, prosecution cannot build up a new case, entirely new case.
Whether 354 is a lesser of
Lesser of.
I understand layperson, but that ought to have been informed me about before the court convicting me, man.
before altering the
Yes, there was no alteration, nothing, man.
alteration of charge.
Only in the judgment we have come to know that I was convicted.
But for in case of lesser offense,
Court
he need
can-
not be, there is no prejudice cause. So he
That
need
at
not
least
be
I
put
should be
into
informed because
notice.
there is a case of prosecution put up, he cannot put up a new case, man.
Now you are behind the bar.
No, I'm on bail.
You are on bail.
But they
So-
have 389 application.
Yes. Submit II.
Ah.
So in this case, let the petition be admitted, my lord, records may be called for.
Now, Mr. P. Kotoke, learned counsel for the petition, learned counsel for the petitioner, also heard Miss S.
Yeah.
Jahan, learned additional public prosecutor. This application under section 397/401 of the Code of Criminal Procedure has been filed, impugning the judgment and order dated 11/8/2023 passed by learned Sessions Judge Sibsagar in Criminal Appeal number 41/4 of 41/4.
That is the
Normally, this kind of
yeah, I understand, my lord. I am coming to it. 41/4, my lord, that is
4
there.
only. Page number 37.
Page 37, 38 also, your lord will find. Sibsagar.
41/4 of 2019, whereby the appeal preferred by the present petitioner before the said court, impugning the judgment and order passed by learned Sub-Divisional Magistrate Sibsagar in GR case number 690/2021 was dismissed. The first appeal was dismissed.
Yes, appeal was dismissed, my lord.
First was dismissed, and the judgment passed by the learned trial court was upheld.
Upheld.
Stop. By the judgment passed by the learned trial court, the present petitioner was convicted under section 448 of the Indian Penal Code and was sentenced to undergo simple imprisonment for 3 months and to pay a fine of ₹1,000, and in default of payment of fine to undergo further imprisonment for 7 days. He was further convicted. He was also convicted under section 354 of the Indian Penal Code. And was sentenced to undergo simple imprisonment for 1 year and to pay a fine of ₹5,000, and in default to undergo simple imprisonment under section 354. Stop. The let the case record of both the case record would be
Both
required.
the
Both the
case.
cases.
Let the case record of criminal appeal number 41 within bracket 4 of 2019 be called for from the Court of Learned Session Judge Sibsagar, as well as case record of
Yeah, okay.
GR case number 690/2017 be called for from the Court of Learned as Subdivisional Judicial Magistrate Sibsagar. And let the notices be issued to the respondent. The learned additional public prosecutor appears as learned additional public prosecutor has appeared for respondent number 1. No formal notice need to be issued to respondent number 1. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice to respondent number 2 by registered post with AD within 3 days from the date of this order, returnable after court.
There is an IA matter. Uttar Pradesh Interlocutory application
He may remain on the previous bill.
that pending
Yes, sir.
disposal matter of the revision application. Then the
This,
operation will start.
Directed to appear before the learned trial court on 11, no, to serve out the sentence. Oh, he was directed to surrender and appear
But
on
yes,
11th to serve out the sentence. Now, he is not on previous bail.
no, actually, he did not appear, he took time.
okay. This interlocutory application has been filed under section 397 of the Code of Criminal Procedure, praying for suspension of the sentence imposed on the petitioner by the yours
SDGM Chittagarh.
by the learned subdivisional judicial magistrate Sibsagar in GR case number 690/2017, whereby the present petitioner was convicted under section 448 of the Indian Penal Code and was sentenced to undergo 3 months simple imprisonment and to pay a fine of rupees 1,000, and in default of payment of fine to undergo simple imprisonment for 7 days. And also he was convicted under section 354 of the Indian Penal Code and was sentenced to undergo simple imprisonment for 1 year and to pay a fine of rupees 5,000, and in default to undergo simple imprisonment for 3 months under the said section. Learned counsel for the petitioner has submitted that the petitioner has preferred a criminal had earlier preferred a appeal before the first appellate court, that is the learned session judge Sibsagar, against the order of conviction and sentence passed by learned trial court. However, the said appeal was dismissed. Now the petitioner has preferred a criminal revision before this court, which has been registered as criminal revision number 5500/2023, where both the order of the in this criminal revision we will only go into appellate court judgment or both,
Both. We have challenged the both.
where both the order of the first appellate court as well as trial court has been put to challenge. Learned counsel for the petitioner has submitted that though initially the charges were framed against the present petitioner under 354B during the trial, however, he was convicted under section 354 without affording any opportunity before
Regarding alteration of charge.
regarding to make his submission regarding alteration of charge. It is also submitted that there is a possibility of setting aside of the
Impugned judgment.
impugned judgments by in the connected criminal revision, and hence he has prayed for suspension of the sentence during pendency of the connected criminal revision.
Only one rider is there, I think, in 401. Any order should be after
The
this
result of
hearing the aggrieved party. I think 401,
yes, that I have.
389 application can entertain.
But
No order under this section shall be made to the prejudice of the accused or other person
what is your
unless.
submission?
No, that is regarding 401, my lord, will come, my lord, up, setting aside.
No, even 389 person. No.
No, this is not 318,
No, this is not 389.
But then
This is
389
under 397.
397.
397.
There is no writer.
Where is the provision? Let us see.
401, there is the
Because
provision.
we have come against not
That
401.
power to suspend the sentence.
Not there is 397, my lord. There actually, if a person is in custody, he may be allowed to go on. That power is there.
Where is please read.
397, High Court or Session Judge
Yes.
may call for examining the record of any proceeding before any inferior criminal court situated within its local jurisdiction for purpose of satisfying itself, so as to the correctness and legality or propriety or finding and sentence and order recorded past as to the regularity of the proceeding of such inferior court, may call for such record direct the execution of any sentence or order, be suspended, and if he is accused of confinement, he is acquitted.
That is
So that
there.
power is
So it is under 397.
so we have filed the IAT under 397.
Considering the submission, what is your submission?
Yes, under this, the power of revision shall not be exercised if an application under the High Court. Yes, under 397 it can, and 401 also there is power.
But we have,
Because-
because
Huh. And he has made his application under
307.
397.
Considering the submissions made by Learned, you are not opposing.
It's provided under the Act. So
Learned
Let's agree to
additional public prosecutor does not opposes the prayer for pendency of the suspension. Prayer for suspension of the sentence during the pendency of the connected appeal. Hence, now after considering the submissions made by Learned Counsel for both the sides, and after perusing the materials available on the case record, the prayer for suspension of the sentence during the pendency of the connected criminal revision petition, that is criminal revision petition number 500/2023, is hereby suspended, and the petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of Learned SDJM Sipsagar. It will
Lordship, in that sentence where your Lordship has dictated, I don't have any objection, can write one more thing that in view of 397 and 1 year incarceration.
Learned Counsel.
Yeah.
No, in the earlier paragraph, the Learned Public Prosecutor does not opposes the prayer for suspension of sentence during pendency of the connected criminal revision petition in view of the fact that the sentence imposed on the present petitioner is for a limited duration of 1 year, and in view of the provision for suspension in section 397 of the Code of this interlocutory application is according to this code.
LCR is 48, yeah.
Next is a Lordship, item number 13 may be kind pass for timing.
It is for setting aside the NBW and all.
Is on lag in court number 9. Of like,
Item number 14,
Yes.
Lordship, co-equity application, Lordship, posting of an order is 28/2/23, page 12. in this case, Lordship, 32 was submitted. Lordship. In fact, Lordship, in this case, what happened? I was in Surat, Lordship, for business, some business purpose. I'm not aware of the case, and no someone was received by me, Lordship. In fact, I'm not aware of the case. And subsequently, when I returned to Nagaon, Lordship, I came to know of this case, Lordship. So, my only humble prayer, Lordship, let me appear, Lordship, and this order, my Lordship, make it in evidence, Lordship.
Let him
Yeah.
appear.
And another order also, Lordship, can page 13, Lordship. I also annex another order.
The case has been filed after issuance of standing warrant.
Lordship.
The case has been filed by the trial court.
Could not be executed. No, the PNA could not be executed.
So standing warrant is issued again.
And-
Standing warrant of arrest.
You are willing to appear.
Appear.
Heard Mr.
Yes, sir.
A.
Case is
Sharma,
filed.
A. Sharma, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973 has been filed by the petitioner Bubu Deuri, praying for quashing of the
Order date 28
order
to
dated
2020.
22/2022
2020.
20 passed in PRC case number 735/2015 by learned Judicial Magistrate First Class Nagaon under section 279/338 of the Indian Penal Code. Learned counsel for the petitioner has submitted that in PRC case number 753/2015 charge sheet was laid against the present petitioner. You were shown as an absconder, showing him as an absconder, and by order dated 28/2/2020, non-bailable warrant of arrest were issued against the present petitioner, and the order for proclamation and attachment of his property were also passed by the learned trial court. Thereafter, it is further submitted that thereafter, or by order dated 16/9/2023, the PRC case number 753 was filed after examination of the executing officer of the proclamation and attachment order issued against the present petitioner, and a standing warrant of arrest was issued against the present petitioner. Learned counsel for the petitioner has submitted that the petitioner was unaware of a pending case against him before the Court of Learned Judicial Magistrate First Class Nagaon, as during the said period he was
In Surat,
in Surat for his livelihood
page 11.
stop. It is further submitted by learned counsel for the petitioner that the petitioner is ready to face trial and ready to cooperate in his trial by appearing before the learned trial court. And his only prayer to facilitate his appearance before the learned trial court. And he apprehends that he may be arrested as a standing warrant of arrest has been issued against him. Considering learned additional public prosecutor does not opposes the prayer of the petitioner to facilitate his appearance before the learned trial court on assurance that the petitioner would be facing the trial pending against him. Considering the submissions made by learned counsel for both the sides, this criminal petition is disposed of with a direction to the petitioner Babu Deuri,
Bubu Devi.
Bubu Deori to appear before the Court of Learned Judicial Magistrate First Class Nagaon within a period of
10 days.
10 days from the date of this order, and during to facilitate his appearance before the state court, the operation of standing warrant issued against him by the Learned Trial Court by order dated 16/9/2023 shall be kept in abeyance for next 15 days. With above observation, this criminal petition is thereby
Apply.
I'm sorry to mention, my lord, item number 32 and 33, my lord. My lord, as per the order, we have filed to affidavit, but it is not on record. May I please call for, sorry to mention this time.
In item number 15, there seems to be some settlement going on.
Settlement is just not, but in the 164 statement,
No, no, there are
क्या लिखा है तेरे को? 15 में है जन? हाँ. If the case is very.
What is your prayer in this case?
to quash the FIR, your lordship.
Quashing of the FIR. FIR is under section 376.
Lordship. 366, 376, and section 4 of POCSO. There is a love affair between both these persons, your lordship, the petitioner and the victim. Victim is about 18 years, just below 18, about 17. And the father, the respondent number 2, he was not agreeable to the marriage. So he lodged an FIR alleging these things, but the victim in her statement under section 164, he has clearly deposed that as such no such incident had happened. And secondly, your lordship, the father is also now ready, and he has also filed an affidavit stating that he has filed the case under misunderstanding and misconception, which is also on record, your lordship. Now, this honorable court, while after the lodging of the FIR, the petitioner was arrested, and this honorable court, the petitioner approached this honorable court for bail, this honorable court for the city, and after perusal of the city, I have just at page number 29, where it is found that in her 164 statement, it clearly denied any allegation against the petitioner. And
You're on bail.
I'm on bail.
Okay. Then let us call for the
And let the notice go to the informant.
informant. Heard Mr. M.H. Laskar, Learned Counsel for the petitioner. Also heard Ms. S. Jahan, Learned Additional Public Prosecutor. This application under section 482 of the Code of Criminal Procedure has been filed by the petitioner Pallab Das, praying for quashing of the FIR dated 29/5/2023, lodged by the respondent number 2 before the Ramkrishna Nagar Police Station, on the basis of which Ramkrishna Nagar Police Station case number 81/23 was registered. Issue notice to the respondent. You have not made PP as a party.
No, respondent number 1, I think we are there.
Yes,
Oh, yes.
yes. It is the
Respondent as Learned Additional Public Prosecutor has appeared for respondent number 1. No formal notice need to be issued to respondent number 1. As regards the respondent number 2 is concerned, the petitioner shall take steps for issuance of notice to respondent number 2 by registered post with AD within 3 days from date of this order, returnable after 4 weeks. Let also the case diary of Ramkrishna PS case number 81/2023 be called for. Let this case be listed. Whether a fixed date, after 4 weeks, a fixed date.
January.
4th January, 4/1/24.
4/1/20.
Let this case be listed on 4th of January 2024.
Stay at it. Then bail का समय होता है. Lodge.
Oblige.
No, no bail कैसा किया?
Lordship, 438 application number. And the FIR may be seen at page 8, my lord.
Here, my lord, I am the housewife, my lord. Here, I am the wife of accused number 1, Mohar Ali. And Mohar Ali, he has been already arrested, my lord. And my lord, the allegation is that, my lord, there was a land dispute and a joint fight took place. And the informant side has got injuries, my lord. Now, my lord, I being a housewife, my lord, I have never participated, my lord, in the quarrel. But to harass, my lord, I have been implicated in the present case. Moreover, my lord, I have a 9-year-old, my lord, daughter, who is reading class 3, my lord. I may be allowed to go for bail, my lord, interim bail, my lord. If anything found, my lord, against me, my lord, on the next date, my lord, it may be cancelled, my lord.
No overt is attributed to any of the accused persons. Simply that they had come armed
Let
and
her appear.
let her appear.
Case diary would be required.
Case diary would be required. Section 34 is there. Let us see.
Heard,
M. Ali.
heard Mr. M. Ali, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Musammad Rantaj Khatun, who is apprehending her arrest in connection with Obhayapuri PS case number 468/2023 under section 326/354B/34 of the Indian Penal Code. The gist of accusation against the present petitioner is that on 12/10/2023, the victim / first informant had lodged an FIR before the officer in charge of Obhayapuri police station, inter alia, alleging that 3 numbers of accused persons named in the FIR, including the present petitioner, had assaulted the first informant and caused injuries on her person. And they also had torn the clothes of the first informant and tried to outrage her modesty. So, learned counsel for the petitioner has submitted that in the meanwhile, the husband of the present petitioner, who is named in the FIR as accused number 1, has already been arrested. Learned counsel for the petitioner has also submitted that the present petitioner is a woman and is having a child of 9 years, is having a daughter of 9 years of age who studies in class 3 and is wholly dependent on her mother. It is further submitted that the petitioner is ready to cooperate in the investigation. Stop. On the other hand, learned additional public prosecutor submits that the perusal of the case diary would be necessary for consideration of the instant bail application, anticipatory bail application. So hence call for the case diary fixing.
25th of December? Oh, 18th of December?
18th.
18th of
My
December.
lord, another bail application of husband of the present petitioner is fixed on 30/11/2020.
Case diary has been called for
Yes.
fixing
30/11.
30/11 for case diary. However, in the meanwhile, considering the submissions made by learned counsel for the petitioner and also considering the fact that the main accused named in the FIR, who is the husband of the present petitioner, has already been arrested, the present petitioner,
They have to bail.
namely Rontaz Khatun, is hereby directed to appear before the investigating officer of Obhayapuri PS case number 468/2023 within a period of 10 days from the date of this order. Stop. If she does so within the stipulated period of time, in the event of her arrest in connection with Obhayapuri PS case number 468/23, the above named petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with a condition that the petitioner shall cooperate with following two conditions. Condition number 1 and 2. Let this case be listed again on 30/11/2023.
On 30/11, it will not be even 10 days, as your lordship had said. So,
Let us see. Because that is the outer limit. She can
Mm.
go even before.
even after that.
Obliged.
Similar is the case here.
Back to your lordship.
No?
My lord, the incident was
Oh.
took place on 30/12/2022, my lord. There was Marpit, my lord. But
149 Asatla.
the petitioner is not name accused, my lord. His name is not in the FIR, my lord. But anyway, the 302 is there, my lord.
302 is there.
Yes, my lord. That's why, my lord, the call for the case diary, my lord.
302 is added later.
Added later, my lord.
Initially, no one who died.
His brother. Harun Rashid.
Harun Rashid.
What is the name of the petitioner?
Yeah, Bajrul
Bajrul
Huda.
Huda.
His name is not there in the FIR. But
Now the my lord, the
Video.
police
Now, one, why are you apprehending your arrest if your name is not there?
because my lord, now the police visiting his house,
Searching
my
it.
lord, charging him. That's why he's in apprehension, my lord. But he may be
The
arrested.
informant is there.
I am
yes, he knows the
therefore
facts.
informant, and after perusal of the videos, police arresting the accused person. But in the present case, not named in the FIR, but maybe
It might be there in the forwarding
after
report and all.
perusal of the diary.
Oh.
He was
At
also
this-
present.
At this stage, in
You're opposing
yes,
interim prayer for bail.
yes.
Call for the case diary, my
Let us call for the case.
Yes.
Heard Mr. K.C. Roy, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor, as well as Mr.
Ahmed.
M. Ahmed, learned counsel for the informant. Stop it. Considering though the name of the petitioner is not there in the FIR which has been lodged in this case. However, considering the fact that this case has been registered under section 302 of Indian Penal Code, perusal of the case diary would be necessary. Hence, call for the case diary fixing.
On 30th of November or what? Dhubri. Today is 23rd. 6th of December or
Sixth.
4th of December?
6th of December.
Lord.
Obliged.
তুমি না থাকলে আগে বেল পালে
Made in your 438 application. The petitioner is a businessman, my lord. The FIR, particular is at page 11, and the translated copy at page 7. It was registered under section 395 IPC only. In the past, my lord, this incident happened near my lord Talmara. And all the persons, nobody was injured, my lord. Only 20,000 was looted from them and some mobile phone. How many mobile phones is also not stated. And this person, my lord, out of them, my lord, 4 persons have already been arrested. Here I have annexed the forwarding report.
They
But-
have named you.
Yes, it's 13, 14, 15, page number 13, Lordship. They were arrested.
In the forwarding report,
Forwarding.
face covered
Arbab
persons
Natik.
pretendas during interrogation.
4 persons already arrested, my lord.
Sahada Pat. No, the arrested persons were two. Thank you.
Total 4. Name of it. Page 18 of chapter 7.
Oh, yes, three. তিনটা है পাশে?
Yeah,
ও চাৰিটা অ।
চাৰিটা।
Let us call for the case.
Lordship, things are not clear from here.
Well,
If they Lordship allow, then he will be
No,
If there
this
before
is
the
the
IO.
case of FIT. Let us peruse the case. Heard Mr. R. Goswami, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor. Considering the nature of offense involved in this case, perusal of the case diary would be necessary for consideration of the instant bail and its bail application. Hence, call for the case diary.
I think total persons were 4 or 5. 4 have already been arrested.
Let us give it a shot. When
No,
can,
around 5-6 culprits
And
who were
all
so
they were
5-6.
covered.
why are you apprehending your arrest?
Businessmen, my lord.
No, there must, why, how you are implicated in this case? Because your name is not there in the FIR.
This was also covered with plots at that time.
The apprehend can I go?
This is only apprehension, Lordship.
He arrested people must have taken his name. That is also not clear from the
I know.
forwarding.
I know.
But
Nobody.
how
nobody has
he is
been-
apprehending,
We are fixing a short
not, yes. 30th of November?
30 November for case.
Obliged.
कोई भी ना 20 Okay.
May I please? 22 30th application, madam. FI page 7.
I am taking 1 minute break.
Lordship, this is not feeling proper. ইমান এচিটো বন্ধ কৰি দিব ঠাণ্ডা লাগিছে ন তেখেতৰো লাগিল চাগে অ সেইটো হয়
Block Elementary Officer of Block Elementary Education Officer Command Dhukokhana lodged an FIR before the officer in charge of Dhukokhana Police Station inter alia alleging that the headmaster, that one Konok Gogoi, the headmaster of number 542 Lahibari Lower Primary School had indulged in certain financial irregularities and has misappropriated funds which were allotted for purchase of ceiling fans and some other
Uniform.
school uniforms. Learned counsel for the petitioner submits that the present petitioner is the
CRCC Cluster Resource Center Coordinator
Cluster Resource Center Coordinator of
in Dhukokhana
Dhukokhana
Education Block
in Dhukokhana Education Block
under Sarvasiksha
under Sarva Siksha Mission
Abhijan Mission Assam. Now it is called Samagra Shiksha Assam.
under Samagra Siksha Assam, and he has not been specifically named in the affair. It is further submitted by learned counsel that the perusal of the FIR would show that the specific allegations are leveled against one Shri Kanak Gogoi, who is the headmaster of 542 number Lahibari Lower Primary School, and nothing has been mentioned against the present petitioner in the FIR. It is further submitted that the present petitioner is being searched by the police and therefore he is apprehending his arrest. However, he is ready to cooperate in the investigation stuff. On the other hand, then an additional public prosecutor case diary would be required.
No, in fact, all the employees of the school were
Involved.
no,
Let
no,
us-
no. Yes, the allegation is that they are searching that allegation is nowhere in the papers, but they are searching, thinking that.
The learned additional public prosecutor submits that perusal of the case diary would be necessary. Hence call for the case diary.
On December, 18 December,
18 December for case diary. However, considering the fact that no specific allegations are leveled against the present petitioner in the FIR, he within bracket name of the petitioner, Hemanta Kumar Borwa, is hereby directed to appear before the investigating officer of Dhokahana Police Station case number 132/23 within a period of 10 days from the date of this order. And if he does so within the stipulated period of time, in the event of his arrest in connection with Dhokahana PS case number 132/23, he shall be allowed to go on interim bail of rupees 30,000 subject to the satisfaction of 30,000 with one surety of like amount subject to the satisfaction of the arresting authority. Let this case be listed again on 18th of December. 18th.
Public.
1812. এইটো দেখোন একো নাই, overtake নাই নহয়. Similar is a case here, no overtake, but names are there.
Document, what happened, my lord, on that day, my lord, my niece wedding ceremony was going on, my lord. So, my lord, the groom side, they came, they blasted some crackers, my lord. Then some altercation took place with the groom side and the, my lord, my neighbor. Then, my lord, regarding blasting of crackers, my lord, in the night. So, my lord, so, my lord, due to the altercation, my lord, they have lost this FIR, my lord, exaggerating the fact. And both the bridegroom families were implicated, man. The whole families are implicated.
No, but there is allegation of sustaining grievous injury.
There are allegations, yes, these below noted persons have entered. That marriage story is not there, not reflected in the FIR.
But I categorically stated, my lord, that when the marriage ceremony was going on, there were alterations. It's a fact, my lord.
149 is there again, 143.
Some of them may be involved.
None of them may be involved. And
Yeah.
Abed Ali is number one here.
Number one, my lord. He's number one.
You are Abid.
Abid.
Let us peruse the case.
Well, some interim protect because my niece wedding was going, ceremony was going on. Then the groom side, they blasted
No,
crackers.
we don't know what is the injury.
Then, my lord, lordship may fix the short date,
Short
calling
date.
for the injury report, man. If the injury report,
Mr. S.M. Abdullah P. Then counsel for the petitioner also heard Ms. S. Jahan and an additional public prosecutor. Considering the nature of allegations leveled against the present petitioner in the FIR, perusal of the case diary would be necessary. Hence, call for the perusal of the case diary along with the injury report would be necessary. Hence,
First
call
of
for
December.
the same. Fixing
1st of December.
first of December for the case diary. And
oblige me.
I don't know, but
That people are. My lord, before my lord, going to
the FIR, my lord, I beg to my lord, show my lord appointment letter of the petitioner, my lord, page 16, my lord. He was, my lord, appointed as a, my lord, invigilator in the examination hall, my lord, by the, my lord, center superintendent, G.C. Pal, of Education, Korimganj, my lord, Korimganj, Assam, my lord. And this, my lord, informant, my lord, since the beginning of the, my lord, examination, my lord, disturbing, my lord, to favor, my lord, is some, my lord, near and near, my lord, student, my. But this petitioner, my lord, did not allow, my lord, FIR page 9, my lord. As a result, my lord, on the last day of, my lord, he is working as a, my lord, invigilator. He lodged this FIR, my lord, with, my lord, completely false allegation, my lord. Thereby, my lord, when, my lord, these papers were, my lord, sent to the, my lord, destination to keep, my lord, in the safe custody, my lord. With this, my lord, false allegation, my lord, this he got, my lord, these papers, my lord, of the, my lord, innocent, my lord, examinees, my lord. And accused number 2 and 3 also, my lord, arrested, my lord, in this case. But as the petitioner, my lord, was working as invigilator, my lord, I have stated in the paragraph, my lord, 3 of the petition, my lord, that, my lord, prima facie, my lord, police came to him, my lord, but as he was working as, my lord, invigilator of the examination, my lord, and he was not in the possession of any document, my lord, police, my lord, did not disturb, my lord. But as his name in the FIR, my lord, he is apprehending still, my lord.
Imdaduddin Majumdar has been mentioned twice in the FIR. Lordship will see.
And his
Accused-
name, he's named as an accused in one.
And 3 also. Son of same Nurul Haq. Perhaps registry vernacular.
My lord, this,
Yes, two. Who is number 3 who has been
my lord,
already
2
arrested?
and 3, my lord, arrested, my lord. I have stated, my
No,
lord, that
3 and 1
Same person.
same to appears to be same person.
And vernacular he
Name.
has not annexed.
my lord, Imad, my lord, or Imdad,
Perhaps.
my lord. One is Imdad, my lord, and he is, my lord, Imad.
Oh, Imad.
Father's
Father's,
name.
Father's name, my lord, same, my lord.
they are brothers.
Brothers, my lord.
One is Imaduddin, one is Imdaduddin.
Yes, my lord. And, my lord, he was in the college, my lord, and this paper were, my lord, found along with, my lord, petitioner number 2, accused number 2 and 3, my lord.
But in the FIR, it's written that fake question papers were
Allegations, considering the
very
allegation, perusal of the case, there
serious. Will
is
be necessary.
My lord, here, my lord, all the, my lord, documentary evidence, my lord, and he is, my lord, prima facie, my lord, invigilator, my lord.
no, maybe. Then
But there was a joint operation and fake question papers were found from
And,
there.
my lord, from the
So-
FIR, my lord, he, my lord, my allegation is different, my lord, page 9, my lord. Lordship, kindly have a look. He is stating that, my lord, since last few years, my lord. Meaning there, my lord, he is the main culprit, my lord. And, my lord, I am stating in paragraph 3, my lord, that he, my lord, asked the petitioner to do, my lord, irregularity in the examination, my lord, in favor of his, my lord, student. And petitioner did not agree. Therefore, my lord, on the day of examination, my lord, when, my lord, papers are being sent to the, my lord, safe custody, my lord, in the middle, my lord, he harassed the petitioner. Nevertheless, my lord, petition accused number 2 and 3 were arrested, my lord, and petitioner number 1, my lord, he is, my lord, Imdad, my lord, Uddin, my lord,
we
and
are
he is,
giving a short date.
Lordship, this is what.
Short date for perusal of the case, there would be
1st of December.
heard Mr. A. M. Bormiya, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional for the prosecutor. Considering the nature of allegations leveled in the FIR, perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary fixing 1st of December.
First up.
Deep local.
To Imdadul.
Okay, now. My pleasure. Impune FIR is page number 9 years. Yes, so close FIR. Page number 9, another one is the impune FIR. I read it.
Moile. Nai more, no?
He was arrested in connection with our Cruz case, Your Lordship, subsequently, Your Lordship. Page number 16, Your Lordship, and exact 2, Your Lordship.
What is your name?
Shahjahan alleged is the name of victim, Your Lordship. Both the
Imdad-
petitioner are brother, Your Lordship. Brother. Page
Imdad,
number 16, Your Lordship, Cruz FIR.
Filed by
And
Imdadul.
exactly. Filed by our brother, Your Lordship. 3 brothers, Your Lordship.
now what was the injury caused?
Lordship, page number 16, may kindly, Your Lordship. The victim, Shahjahan Ali, Your Lordship, tried to rape our daughter, Your Lordship, Noor Hassan, age 7 years.
Shahjahan is your own brother.
No. Shahjahan is the victim, Your Lordship, in the impune FIR, Your Lordship. Imdadul Haq and Maham Ali, and both are brother. Petitioners are brother, Your Lordship.
Okay.
Shahjahan Ali, another person, adjacent house, resided, Your Lordship. Page number 16, Your Lordship, can you be curious, Your Lordship? Our FIR.
So that
Clause
FIR,
RTR, Your Lordship.
I think 1510 FIR preceded the present FIR.
Lordship.
It is one day later. On
Lordship.
16/2,
Will
Shah Jahan
earlier
was
and while visit his house, Your Lordship, some quarrel took place, Your Lordship. Actually, he tried to commit rape of our daughter, Your Lordship. Daughter of our brother, Your Lordship, is 7 years.
This
And
is a
a
retaliatory
case
act.
registered, Your Lordship.
The application under section 439 of the Code of Criminal Procedure, 1973 has been filed by the petitioner, namely Sri Shubhrajit Bora, who has been detained behind the bar since last 47 days, that is, since 9/10/2023, in connection with Noonmati PS case number 297/23 under section 302 of the Indian Penal Code. The accusation against the present petitioner is that on 8th of October 2023, one Shri Suresh Dorji lodged an FIR before the officer in charge of Noonmati Police Station, inter alia, alleging that the son of the informant, namely Rohit Dorji, was found in an unconscious state at Ganesh Mandir Path on 7th of October 2023 at 6:30 p.m. And before the death of the son of the first informant, he had gone to meet the present petitioner at his Vijayavati apartment at Ganesh Mandir Path by lane. And it is alleged in the FIR that the petitioner is suspected to have killed the son of the first informant. Learned counsel for the petitioner has submitted that the allegations leveled against the present petitioner. No, you took the petitioner in a scooty after he was found unconscious.
Yeah, then when he was unconscious, then my lord, the petitioner, he requested the security guard of that to help him to put him in the scooter.
Okay.
The security guard put him in the scooter, and petitioner took him in the scooter.
I think
But how he was found in
Yes,
road?
maybe lordship, he was already dead. That is why he fell in the road. But it was not driving by the victim. It was driving by the petitioner, Shubhrajit Bora. And his statement also recorded, lordship. He said that they took drugs. And maybe, my lord, overdose, my lord. The postmortem report may not receive, Lordship. That is the one.
Okay. What was that? In the FIR are not true. Are not true. And he is innocent. It is further submitted by learned counsel for the petitioner that considering the period of detention of 47 days already undergone by the petitioner, he may be allowed to go on bail. On the other hand, an additional public prosecutor has produced the case diary of Nunma TPS case number 297/23, which was called for in connection with this case, and has submitted that from the postmortem
No, postmortem report not received, Lord.
that the postmortem examination report has not
Not received.
received. Then from where you are saying that no injury was
No, my lord, in the, my lord, inquest report, Lordship.
from the inquest
Yes,
report
my
of
lord.
the deceased, which is available in the case diary, it appears that no injuries were found on the dead body of the
Only, my lord, in the right foot, Lordship. Some abrasion type, Lordship. Otherwise, no such thing.
on the dead body of the deceased, except some abrasion on the right foot of the
My lord.
deceased. It is further submitted that the evidence shows that the materials available in the case diary shows that the victim was found in unconscious state in the apartment of the present petitioner, and he sought help of a security guard to carry the present petitioner to
To, my
hospital.
lord, to help him to, my lord, take him in the scooter, Lordship. That is the statement of the security guard, Lordship.
However, at that time he was already in unconscious state. It is also submitted that there is also materials to indicate that the deceased took
He took the, my lord, this person in the scooty outside of the flat, Lordship.
drugs.
Yes, that is the statement of the, my lord. It is not, Lordship.
The petitioner,
And the victim, Lordship. This is,
both of them took,
both of them took drugs.
and there is a probability that the deceased died due to overdose of the intake of drugs. Stop. Though the investigation is pending at the stage of receipt of
Postmortem report.
postmortem report. However, considering the fact that the petitioner has already undergone detention for last 47 days
My
and
lord.
the investigating officer has recorded the statement of flats,
My lord.
the
Seizure has been made, Lord.
statement of witnesses, and the investigation has fairly progressed.
Right.
Further custodial detention of the present petitioner does not appear to be necessary for fair completion of the investigation of Nunma TPS case number 297/23. Stop. In view of above, the petitioner, namely Subhrajit Bora, is hereby allowed to go.
His mother, like Kakoli Bora. Just the petition, accused,
किसको सुप्रोजित हो रहा है?
not Subrajit. Subrajit.
Subhrajit Bora is hereby allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate, Kamrup Metro. With a condition that he shall continue to cooperate with the investigation. with the investigating officer in fair completion of the investigation. With above observation, this bail application is thereby disposed of. Said
Keep
by
clear.
ticket.
Keep clear.
One thing. Kindly turn to page 26. In this case, after receipt of summons, I filed some application for seeking time, and that was allowed. And subsequently, in this order, by this order, Lordship, my fourth prayer was rejected. That your Lord, may I read Lordship that order? Accused persons Asabuddin and Monoy Ahmed are absent with state. It is seen that the accused persons are repeatedly taking time for appearance since 1/9/2022, thereby causing delay in the proceeding of the case. Hence, the petition to condone the absence of the accused person is rejected. Issue NBW against the accused person. Now, Lordship, may I kindly turn to page 27. Accused person.
Yes.
Accused persons Asabuddin and Monoy Ahmed are absent without stay. NBWA has issued against the accused persons returned with report. Peruse the same. It appears that the accused are concealing themselves to avoid the service of the said warrant. As such, issue press NBWA with warrant of proclamation and attachment against the accused person Asabuddin and Monoy Ahmed. The warrant of proclamation shall be published in a local daily newspaper of the locality of the accused in addition to publication in usual mode. The newspaper carrying the state proclamation shall be submitted on 21/8/2023. Send a copy of this order to the officer in charge of the concerned police station with the warrant along with a direction to submit report regarding execution of the warrant on the next date fixed. So here my case is that Lordship, as there was some apprehension, so I could not appear.
Now proclamation has been
Issued.
issued.
And proclamation Lordship, as your Lordship knows, just I'm taking your Lordship to section 82 of CRPC Lordship.
Yes.
82 subclause 2, the proclamation shall be published as follows. That number 1A, it shall be publicly read in some conspicuous place of the town or village in which such persons ordinarily reside. B, it shall be affixed to some conspicuous part of the house or homestead in which such person ordinarily resides or to some conspicuous place of the town or village. C, a copy thereof shall be affixed to some conspicuous part of the courthouse. Now, the part that subclause 2, Lordship, Roman 2, that is in addition to number 1. So here newspaper
Number one
publication
has to be followed.
follows, then newspaper publication will come.
Okay.
So that order may be set aside, and then Lordship, I will be allowed some protection, he will appear before the court. Because the word is may also in Roman 2.
Now from the order, how you can say that Roman 1 was not followed?
Here, Lordship, it is said, just again, I'm page 27. The warrant of proclamation shall be
That may
published
be in addition to 1.
in addition to publication in usual mode. So what is the usual mode? That is not there, Lord.
The usual mode is there in the CRPC.
Lordship, just
In addition to publication,
in addition to first, Lordship, they have to follow that Roman 1. 82. Subclause
no,
2.
how this order is violative of 82. It
That
says
you-
that first you follow the usual mode
Lord.
and then thereafter
in addition to that newspaper publication.
That has been directed by the court. Court has also said that first you publish it through usual mode and thereafter by publication. So how court is wrong?
But if you also see that usual mode, that is not defined here, Lordship. But the
Usual
second
mode
line
is
of
the usual mode is the
Second-
mode prescribed in 2 clause Roman 1. That is the usual mode. A, B, C. That it has to be read in that manner.
But in next paragraph, your Lordship will find that newspaper carrying the state publication shall be submitted on 21/8/2023. Nothing about that usual mode. Lord. Next sentence in the order.
Now what do you want?
My prayer that order may be stayed and some protection will give. They will appear before the trial court and face the trial, whatever consequences there. Without fail, they will appear.
The
For a limited period, they may be protected for 10 days, 15 days.
My lord, otherwise I would have not objected, okay, but they have sent in the order dated 11/7/2023. That is the subsequent order, Lordship. But prior to that, there was an order dated 10/5/2023. That is Annexure 7, page 26, Lordship.
no other
No, the question is that, Lordship, why they have not appeared? They must have cited some ground. That these are the circumstances for which we could not appear before the trial court. That is why we have filed application to condone our absence, to pardon our absence, Lordship. Now, Lordship may kindly peruse the order dated 10/5/2023, Lordship.
no no
Accused-
Mr. Purva, what
My
I
lord.
propose,
My
we
lord,
are not touching the impugn order.
my lord.
We are not in any manner saying that impugn order is wrong. We are only what I propose that keeping it in abeyance
My lord,
and let him pray before the trial court.
my lord, to
And-
that extent, I do not have any objection, Lord.
You only giving protection for 10 or 15 days so that they appear before trial court
My lord,
and ultimate relief they will have to seek before learned trial. Will it,
Lord.
is it okay?
Lord.
Uh, now, why you did not appear? What is the reason? Because you were knowing the dates. You were aware of.
But I do not know what is written
There is
in
no
the
ground in the
That is
petition.
the most important thing to get even interim relief.
Yes, Lord.
Unless there is a genuine ground,
There is no
you
ground
may-
in the petition, Lord.
you
Where
may
there is
not
no-
get any protection from this court. Merely approaching the court would not, is not sufficient to get a relief.
Lordship may observe that they will justify at the time of hearing of the application why they have not appeared
No.
during that period.
But for getting an interim
Because
relief
what?
from this court, you have to give some justification. You may take instruction. I am not passing order now.
But-
Because
I have
otherwise it would mean that merely by approaching High Court you would get any relief. You have to justify why you fail to appear in spite of knowing that dates are fixed. If there is a genuine reason, then we will protect you. If there is no genuine reason, you are not entitled to any protection.
They appeared to their counsel. They filed petition.
Appear
Appeared. They appeared that Lordship will find page 23 onward, Lordship. That they filed their application and that was allowed. Page 23, 24, 25. 3 orders were there prior to that order that I have approved. They filed application showing cause.
no, thereafter when non-bailable warrant of arrest were
Lordship may kindly see page 25. Here also their application was allowed and.
no, that
on
is my
10/5/23.
that is my query. When NBW were issued against you on 11/7,
No, 10/5 initially was it. 10/5/2000, page 26. First, my prayer was rejected and NBW was it. I prayed for time to seeking that I will appear on next day, and that application was rejected. Page 26, Your Lordship.
Then from that period till the issuance of proclamation order,
Everything is there, Lordship. Then on 10/5/2023, my prayer was rejected, NBW was issued. Matter was fixed on 11/7. That order, Your Lordship, will find page 27. On the next day, immediately proclamation and arrestment order was passed.
before issuance of this non-bailable warrant of arrest, they were appearing before the court through
To counsel.
Through
counsel. When their prayer was rejected, they
And-
stopped appearing.
No, to the counsel, but Lordship, there must be some reason why they are not appearing, Lordship. Because without their appearance, court could not proceed, Lordship. That is why NBW was issued. Lordship may kindly peruse page 22, Lordship.
What is the reason?
That application, Lordship, I have to see on the which application was filed on.
You can seek instruction. I'm fixing it
Tuesday, Lordship, 28.
Tuesday.
And Lordship may kindly peruse page 22, Lordship. When the search sheet was filed, someone was issued, Lordship. So
on
when
that,
someone is issued, Lordship, normally no court, Lordship, put the person behind the bar on his first appearance, Lordship. That is my Lord, little experience. When the someone is, my Lord, issued.
Now, what is the submission?
So on that, Lordship, I have submitted that the matter is related to, Lordship,
No, on Tuesday you will make oral
Yes, sir.
submissions or give.
oral submission. I will
Let him seek instruction.
Otherwise, I would have not, my Lord, objected to his, my Lord.
Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. R. J. Bodwal, learned additional public prosecutor, who has public prosecutor, learned counsel for the petitioner submits that prays for some time for seeking some instructions from the petitioner on the queries posed by this court. To answer the queries posed by this court, the prayer is allowed. Let this matter be listed again on
29th, Lordship.
29th.
The close, I have to obtain the certificate.
29th October 2020.
Public.
My pleasure. 439 application, Lordship. In this case, Lordship, the accused person was arrested on of 3/4/2023 on the strength of NBW, Lordship. And since after, Lordship, and he once again approached the court below seeking bail, Lordship, and but the Planet Court below was rejected his bail there. And we'll find first reject order, Lordship, page number 13, 15/5/2023. And Lordship, and subsequently again he approached 28/6/2023, Lordship, page number 14, it's rejected, Lordship. And Lordship, charge was framed, Lordship, 11/7/2023, page number 60, Lordship. Charge was framed. Page number 60. And
Yes.
thereafter, Lordship, when someone was issued, Lordship, against the accused, witnesses, Lordship, but they were not turned up, the someone was not turned up, Lordship. And subsequently, Lordship, one more date is given, and I have latest, I have collected the Lordship order copies, and 4/10/2023, I have it given.
What is the next date?
Next date, feast, Lordship.
2/11 is the last date for evidence.
30/11/2023.
2/11 not হয়েছে নাকি?
And Lordship, we have this page, Lordship, and the order kindly may peruse, Lordship, order dated 22/11/2023. That I have provided the certified copy. That's the for moment, Lordship, may I read, Lordship. 2/11/2023. The accused is released before me from jail custody. Other 4 accused persons are present. 3 PWs, namely Yaqub Ali, Ainal Haq, Habibur Rahman are present, but the defense has prayed for adjournment. Right, petition number so filed on the ground of illness of so and the petition is allowed. And after due hearing for the humanitarian region with the cost of rupees 600 to be shared equally by the 3 PWs present who are go on PR form of rupees 500. And the defense has deposited cost amount of rupees 1,000 as per the order dated 4/10/2000 PWs, namely Yaqub Ali, Ainal Haq shall be at liberty to collect the amount to be shared equally by them. And it may be noted here that the several adjournment have been granted to the defense for cross-examination. The above named PWs last opportunity is hereby given for. My lord, after framing the charge, Lordship, once again the PWs are present before this learned below, but not examined, Lordship. But I am in custody about 6 months on the strength of NBW, Lord.
Lordship, kindly peruse the order dated 10/6/23 and 28/06/23. So his past conduct does not inspire confidence that he will appear if he endorsed on bail, because the occurrence took place prior to 6 years ago, and thereafter he has not been dressed out by the investigating officer till 1.5 years, Lordship. But subsequently, on the strength of warrant of arrest, he has been arrested later on.
And Lordship,
And it says the case is very serious, Lordship, 376D.
What is,
page
He is
number
a prime accused, Lordship, and I have gone through the statements, Lordship. 164 statement, and there is an eyewitness, Lordship. They've thoroughly implicated, Lordship. Kindly go through the statements.
Lordship, now we are
Now the
ready to
charges
face
has
the
been
trial,
framed, Lordship, under
Page
section
number 21.
376D.
whether the victim has been examined?
No, Lordship,
No,
not yet.
one witness is actually.
Because only
Lordship,
because
can-
he is shown as absconder. Thereafter,
Yes, your conduct was not.
yes, Lordship.
So that is why I am 8 months in custody and 7 months, 25 days.
So
Subsequently,
without
only one opportunity that because
vehemently
PWs
upset,
are
Lordship, at this
appearing
stage.
before this learned court below, Lord. But
No.
the Lordship, the government
No,
PP is
unless
failed.
the victim is examined,
Yes, Lordship.
No.
because this is
No.
a,
Lordship, otherwise the other accused person, their conduct is kindly make consider,
No,
Lordship.
no, specifically this
let-
person's, Lordship.
And one Tahir Ali, Lordship, and he was arrested in connection with the of the strength of NBW, and subsequently he was released on bail, Lordship. Kindly page number 21. And he released on bail, Lord. Relevant operative control, page number 22. And otherwise, Lordship, all the accused are not regularly appearing, Lord. There are 6 numbers of witnesses. Only one chance may be given, and then all the accused are same villager. Same village. Only otherwise, Lordship, all the accused are not regularly appearing. Even then, the prosecution is failed to examine the witnesses. And it is very clearly reflecting the order. But otherwise, only any stringent condition may be imposed on. And one accused already been arrested and grant bail. And with
At least
extent of
no, but the
NBW.
case could not proceed only because of your default.
Yes, Lordship.
Now I am in 8 months. So in the 8 months, there is nothing.
That
progress in this case.
indefeasible right goes, Lordship, after filing of CS. Lordship.
Only but Lordship, at the 8 month in gone, there is nothing any progress in this case.
Let the
Lordship.
victim be examined first, Lordship. Thereafter, Lordship may consider.
How can it is assured, Lordship, when the other witnesses are present if they are not examined? And without examining the victim, Lordship, and other rest of the witnesses are falling by this court below. Why, Lordship? And he is the first witness.
At least, Lordship may
And
give
even
a
then,
direction to expedite the trial
any
proceeding.
any summon was not issued to the victim, Lordship.
Summons are not issued to victim.
No, Lordship, it is the order reflect, Lordship. The other witnesses are appearing. And if the victim is available in the locality, and why he is not tracing out, Lordship? So I am 8 months.
Let her be
If
examined
any-
first, Lordship, and vehemently objected.
Only one such may be given, Lordship, and if subsequently by conduct is will come in bed, Lordship, then otherwise 8 months, 7 months.
Where is the affair?
At page, Lordship.
What is his role?
Lordship, perhaps letter is not annexed here, Lordship.
What is his role in the?
Lordship,
Lordship, I have.
when the
copy of
victim was
FIR.
serious, he was searching for her husband. At that time, Lordship, near the market area, the accused person called her up to a nearby
No,
jungle.
that is a general accusation.
Yes.
But what was the role of the?
Role, Lordship, kindly go through the 164 statement of the victim and the eyewitness, Lordship. It is very much specific.
Lordship, I have the copy of FIR. Lordship, may I read, Lordship?
No, then let the victim. We are issuing instruction direction that let the victim be examined.
Lordship, that will do.
And after examination of the victim, the
Absolutely, Lordship.
trial court
Lordship,
will
it is a woman, Lordship, and a married woman, Lordship.
maybe, but let her be examined first.
Lordship.
After her examination, your
Lordship, I admit, Lordship, but without issuing the notice to the victim, Lordship.
we are issuing that direction.
That direction is going to be given. That
Heard Mr. F. Hawk, learned counsel for the petitioner. Also heard Ms. S. H. Bora, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Abdur Rahman alias Rinku, who has been detained behind the bar since 3/4/2023 in connection with sessions case number 188/2023 under section 341/376D of the Indian Penal Code. Learned counsel for the petitioner has submitted that the petitioner is facing trial before the Court of Learned Sessions Judge. Before the Court of Learned
additional district and session judge Gwalpara.
Additional Sessions Judge Gwalpara in Sessions case number 188/2023. It is also submitted by learned counsel for the petitioner that though the petitioner has been detained behind the bar since last more than 7 months, that is since last 3/4/2023, and though the charges against him were framed on 11th July 2013, not even a single witness has been examined. It is further submitted that the court has not even issued the summons to the victim woman, and though on 2/11/2023, 3 numbers of prosecution witnesses had appeared before the learned trial court. However, they were not examined, and
211 also.
and
Four-
they were not examined, and another date is fixed for their examination. Learned counsel for the petitioner has further submitted that other 3 co-accused persons are already on bail. They are on bail.
Look.
Are already on bail. Stop. Considering learned counsel for the petitioner further submits that the petitioner is ready to cooperate in his trial if he is allowed to go on bail. On the other hand, Ms. S.H. Bora, learned additional public prosecutor, has vehemently opposed the grant of bail to the present petitioner on the ground that the offense involved in this case is of gang rape under section 376D of the Indian Penal Code, and the present petitioner is one of the prime accused in this case. It is further submitted by learned additional public prosecutor that though the incident in this case occurred way back in the year 2000
Lordship, date of occurrence is
15.
2015.
in the year 2015. However,
17, Lordship, I'm sorry, 17.
2017. However,
27/5/2027.
however, due to default by the present petitioner on 2 occasions, the case has not proceeded any further. Stop. I have considered the submissions made by learned counsel for the petitioner as well as learned additional public prosecutor. It appears that the offense involved in this case is of heinous nature, and it also appears that that on earlier occasions the case got delayed due to absence of the present petitioner, and only after his arrest the charges could be framed against all the accused persons. It also appears that the victim woman has not yet examined. Neither nor the record shows that the summons were issued. Learned not yet examined. Stop. Learned counsel for the petitioner submits that even the summons were not issued against the victim girl. Considering the nature of offense involved in this case, as well as conduct of the petitioner in this case, this court is not inclined to grant the bail to the present petitioner at this stage. However, hence the prayer for bail of the present petitioner is rejected at this stage. However, it is hereby directed that however, it is hereby made clear that after the examination of the victim girl, the petitioner may approach learned trial court and may pray for regular bail before learned trial court, which would be considered on its own merit by the learned trial court. It is also directed that if the trial court has not yet issued summons to the victim, the trial court would issue the summons to the victim girl and would make all endeavor to examine the victim as early as possible. With above observation, this bail application is for
Highly authorized, Lordship.
And so it is, my lord, so far contents of the FIR, Lordship, and the one thing is that he is not the, I think Lordship is not the
No,
prime.
that is the submission.
Prime, Lordship. That is the
Submission.
published.
One of the prime actors.
My lord, 439 equation 80 days in custody, my lord.
80.
Yes, 436. My lord,
Dear Lordship, may I submit, Lordship? Search sheet has been filed here.
Charge sheet has been laid.
Yes.
You have to approach trial court. Now, what is your submission?
my lord,
Because now after laying of the charge sheet, you have to go before the trial. Heard Mr. M.J. Borwa, learned counsel for the petitioner. Also heard Ms. S.H. Bora, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, the investigating officer has laid the charge sheet bearing charge sheet number
By its CS number 357 of 2023, dated 39/2023.
in view of the laying of the charge sheet. This bail application is thereby disposed of with an observation that the petitioner may approach learned trial court and may pray for regular bail before the said court, if so advised.
Okay.
bless.
My lord, in this case, the accused person is behind the bars since more than 1 year.
Not a single witness has been examined till date. Now, my lord, what happened? Earlier, this case was being investigated by the Assam police. Later on, this honorable court had directed CBI to investigate, and CBI have investigated and filed charges. When Assam police was investigating the matter, they have never arrested the present petition. When CBI investigated the matter, they also never investigated any of the accused persons. I'll take your lordship to the charge sheet. Kindly come to page number 16. Page number 16.
When the charge sheet was laid,
Charge sheet was laid on 15/12/2021.
and when the charges were framed,
Charges were framed, my lord, on it is charges were framed in the month of August 2023, my lord. August or September. I'll give the date, my lord. Because, my lord, there was an order from this honorable court that we should approach after filing up framing of the charge. So our bail rejection order is 39/2023 after framing of charge. So we have approached in the month of September only, my lord. I'll give the exact date, my lord. Now, my lord,
under what section charges were framed?
302, my lord.
Only.
My lord, 302, my lord. That also I'll inform, my lord. Now, my lord, kindly come to page 16.
Yes.
Kindly see, my lord, this is the present petitioner Mukut Saikia, my lord. And lordship will find Roman 19, status of the accused not arrested. This is the CBI subject. Now, next page, A2, Ras Pritam Chakraborty, A2, page 17. He is also, my lord, not arrested. Then another accused, A3, page 18, Lily Gangwal, not arrested. Another accused, Munni Gangwal, page 19, not arrested. Then, my lord, Raju Gangwal, page 20, no charges has not been laid against him. So these are the accused persons. Now, my lord, what happened, my lord? All the other accused persons had appeared before the learned magistrate by taking protection either from the High Court or the Sessions Court. And
How many accused were there?
my lord, 4, my lord.
Against 4 charge sheet was laid.
Yes.
And out of those 4, 3 are under protection from
High Court or Session Court.
Okay.
And they appeared before the magistrate, and magistrate have allowed them to go on bail, and then they were convicted to Sessions Court. But this present petitioner, he was produced before the court without any protection, and then he was taken into custody. Thereafter, CBI kept on objecting his bail application that if he is released on bail, then it will hamper the trial, but no cause materials are there. I'll place those judgments, my lord.
who is appearing for CBI.
That's what, my lord, today's CBI is not, my lord, their name is also not reflected in the cause list, my lord. That's why, my lord, I am not seeking any order today, my lord. Let CBI be put to notice and registry may be directed to reflect the name of CBI in the cost list, my lord.
There was a prayer for making implement.
Yes, we have done it.
You-
Yes, I think corrected cause list has also come.
Showing their name.
Yes, my lord. CBI online was CBI. Online also, my lord, in the e-courts, my lord, against this bail application number, CBI's name is being shown.
So that prayer goes.
My lord,
That prayer for showing the name of the CBI.
in the cause list, my lord. Cause list is not there, my lord.
Okay.
In the e-courts, it is shown, my lord, but
Okay.
cause list has to be updated by the registry.
Heard Mr. F. Khan, learned counsel for the petitioner, who submits that though the petitioner has impleaded the CBI as respondent number 2 in this case. However, name of the special counsel of the CBI has not been shown in the cause list. So registry is directed to show the name of the standing counsel, special public prosecutor CBI in the cause list. And you have furnished the copies of
No, my lord, we may be directed to furnish the.
The petitioner shall furnish the copy of bail application along with the annexures to the special public prosecutor CBI
By Tuesday, my lord, because Monday is
within 3 days,
3 days, my lord.
3 days from the date of this order.
My lord.
Let this case be listed again on
22, my lord. Because my lord, 20 we will furnish, my lord. 21.
today is 24.
Oh, my lord, sorry, my lord, 28, my lord. 28 or 29,
On 29.
my lord.
Let this case be listed again on 29th of November.
Obliged, my lord.
Next, 439 application, your lordship. Petitioner is behind the bar for last more than 62 days, your lordship. He has been arrested, Raha case number 139, on the basis of an FIR, your lordship, which is annexure A, page 12. But his name and he is not named in the FIR. After lodging of the FIR on 22/6, after 3 months, he has been arrested on 23/9 after 3 months, you know. And the similarly situated persons, though the police has arrested, has granted privilege of granted bail by this honorable court. By observing that the 302 IPC would not be attracted in this matter. So it's a hit and run case, your honor. Annexure C is the bail order. Page 16. Some persons has been arrested in this same PS case, your honor. Annexure C, page 16. And after perusing the case diary, this honorable court on paragraph number 6 of the said judgment order, you know, page 18, paragraph number 6. In view of the Supreme Court judgment, Rita Davis case, the 302 has not been attracted in this entire matter. Though the allegation is of theft of cow and hit and run case, your honor, by hitting two persons. The petitioner is not in the picture. He has been lagging behind the bar for last more than 62 days.
My lord, we have received the case diary, my lord. And here, my lord, the allegation is that all of them went to the theft of cow, my lord. When the owner of the, my lord, they have gone to the, my lord, then they fled away. Through their vehicle, my lord. In the meantime, my lord, they have hit one lady who was standing in the road, my lord, and died in the spot, my lord. Thereafter, the car was accident. And then one accused person was died, my lord.
One accused died.
No.
One accused died, and another lady died.
Informant's father has been expired. Accused not. One accused, one accused.
And still their allegation, my lord.
Now, what
statement-
is the progress?
My lord.
Co-accused have been allowed to go on bail.
My lord. Here, my lord, co-accused statement from the statement of this, he is involved in this case, my lord.
In the
And he
case
also
of,
admitted.
in which case? In cow theft or in?
Cow theft, my lord. All of them in the vehicle, my lord.
Now, we are
My-
concerned with the allegation of murder.
My lord.
Otherwise cannot be taken away because the
When
vehicle,
the
Supreme Court.
Now, how many accused were involved in this case? How many are granted bail?
Three person already been convicted. Annexure C, page 16. Kudus Ali, Zakir Hussain, and Ajibur Rahman. Page 16, Annexure C. These are the applicants.
Otherwise, what is the progress of
My
the?
lord, investigation is going on, my lord.
Because
And
for last 52 days, he is behind.
my lord,
62 days.
60 days, my lord. But there is an objection from the IO also, my lord.
What is the ground for appeal?
My lord. My lord, the alleged accused person to Musa Ali is directly the present prisoner in the case and statement of the arrested accused person, Mohammed Azibur Rahman, so, there in his statement, it is reflected he is directly involved. According to the arrested accused, Musa Ali plead his guilty after arresting. My lord, accused namely Gulzar Ali, Sufiq Islam, Sufia is running away. They are not arrested. If granted bail him, it will a normal booster not only for him but for also other cattle thieves. He is the least respect for the fellow being of the society as well as the law of the land. He and his cattle thieves gang, they are the gang, even did not hesitate to hit and drive two persons with the vehicle only to save their lives.
There is no elements of murder, Your Honor, in this case. If you taken away the 302,
And he may, my lord, commit same offense and hamper and temper evidence, my lord. These are the objection, my lord. But materials is against the present petition also.
Heard Mr. B. Heard Mr. H. Burwa, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Musa Ali, who has been detained behind the bar since 22/9/2023, within brackets since last 62 days, in connection with Roha PS case number 139/23 under section 379/279/302/34 of the Indian Penal Code. The gist of accusation against the present petitioner in this case is that one Shri Shoshindra Nath had, on 22/6/2023, lodged an FIR before the officer in charge of Roha Police Station, inter alia, alleging that on that day, that on 21/6/2023, at around 11:30 p.m., a gang of thieves had committed theft of cows from the house of one Bhuvan Chandra Nath, and when the villagers came to apprehend the cattle thieves, they made an attempt to flee away in their vehicle, and in the process they hit the father of the petitioner, and as a result of which he sustained injuries and died at the spot. Later on,
Well, 3% died in the incident. No, 3. From the accused person also one died.
the only question is the other co-accused are on.
But in the incident, my submission also that 3% died. 11.
The father and mother of the informant died on the spot. It is, and thereafter the vehicle met with an accident. The vehicle, where it fell down,
it is at that's village, Your Honor, Koliha Madi village.
and thereafter the vehicle was and thereafter the thieves were apprehended by the public, who also had sustained injuries. Stop. Learned counsel for the petitioner submits that the petitioner has been detained behind the bar since last 62 days, and other three of the co-accused were already granted bail by a coordinate bench of this court, wherein it has been observed no, that is not necessary. Coordinate bench of this court. Stop. It is submitted by learned counsel for the petitioner that considering the period of detention of the present accused, present petitioner, he may be allowed to go on bail. Also on the ground of parity, as the other co-accused are already released on bail. On the other hand, an additional public prosecutor has opposed the grant of bail to the present petitioners on the ground that in the incident, two of the parents of the informant expired and one of the accused also died. And there are materials on record to indicate that the present petitioner was involved in the alleged theft of cows. At what stage it is pending?
My lord, some of the accused person is yet to be arrested.
Learned counsel for the petitioner has also opposed the grant of bail to the present petitioner on the ground that some of the co-accused are yet to be arrested. However, I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record, including the case diary of case diary of Roha PS case number 139/23. Roha case. It appears that the petitioner has been detained behind the bar since last 62 days, and his statement under section 161 has also been recorded. It also appears that the investigating officer has also recorded the statement of other relevant witnesses under section 161 CRP. Further, it also appears that 3 of the co-accused were already enlarged on bail by a coordinate bench of this court. Hence, merely because of the fact that some of the co-accused are yet to be arrested, same may not be a just ground for detaining the present petitioner any further, if otherwise their custodial detention is not necessary. Stop. Considering the progress made in the investigation and considering the fact that the 3 of the co-accused persons are already allowed to go on bail, this court is of the considered opinion that if the present petitioner cooperates with the investigating officer, his further custodial detention does not appear to be necessary for fair completion of the investigation of the Roha PS case number 139/2023. Stop. Hence, the petitioner Mucha Ali is thereby allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Nagaon with following conditions. Number 1, he shall appear before the investigating officer as and when so required. As and when so required by the investigating officer for fair investigation. Number 2, he shall not directly or indirectly. With above observation, this bail application is thereby disposed. Mentioned by the net counsel, the prayer is allowed. Let this matter be listed after a week.
Lots of lines.
My pleasure.
Yes.
FIR is page number 8, Your Lordship. I am not FIR an accused person, Your Lordship. Nothing was revealed in FIR, Your Lordship. Page 8. On main accused, namely Radha, a transgender, where the victim Indradul Hussain alias Priyanka, transgender person.
What is the allegation?
May I read you? On
Read.
2010-2023, I noticed on TV news channel as well as communicated with the concerned police. Came to know
So,
that someone killed my son, namely Imdatul Islam alias Priyanka, kept in a bag at Sanmari, Guwahati. About 1
case
month.
diary has arrived.
My lord, case they received, my lord. Here the allegation is that
Okay, let him submit.
my lord, transgender, my lord. There, although he is my lord, Imdatul Islam, my lord, he is in the form of my lord, Priyanka, my lord. They are in relation with the my lord. The present petitioner, my lord, here is involvement regarding my lord. He is the boyfriend of the my lord, Priyanka. This is my lord, Imdatul, my lord. And both of them are staying in a rented house, my lord. Both of them living in the rented house, my lord. And here is the my lord, we have received the CD along with the PM report and inquest report, my lord. He was brutally killed by the He was killed by the brutally, my lord. He was, my lord. And 19 injuries are there, my lord. 10 ounces are there, my lord. The dead body was in the bag, my lord. In the Sanmari, my lord, it was recovered.
Now, what are the materials against?
My lord, materials against him, my lord, he is the my lord boyfriend, and both of them are staying in the my lord rented house. Thereafter, my lord, he has stolen one mobile phone, my lord. It was recovered from his possession, my lord. Present petition, my lord.
So, 3 months ago, your lordship, both the petitioner and the victim, your lordship, reside separately, your lordship. In forwarding report started that, your lordship. Page number 14, your lordship, at bottom, your lordship, page number 14.
My lord, here we have received the PM report, but some of the sent for FSL, my lord.
Priyanka left her rented house 3 months ago.
Who is the petitioner? Imdadur.
M.
Hamidur.
Hamidur,
your
my lord.
lordship. And main accused is Radha, your lordship. There is a quarrel took place between the Radha and said victim Indadul, your lordship, in front of the informant. Informant is the mother of the victim, your lordship. Where said Radha, one transgender, your lordship,
No.
written the informant that he will kill her son.
Okay. In the FIR, there is no allegation against
No
Hamidur.
allegation.
No allegation.
What else?
My lord,
remains?
from the case there, my lord.
He is the boyfriend of.
My lord, and both of them are staying in the rented house, my lord, in
Okay.
the Polton Bazaar, my lord. And thereafter, my lord, and during investigation, thereafter he is in another place, my lord, he was arrested from Sipsagar, my lord. And from his possession, my lord, the mobile of the my lord, this is recovered, my lord.
Actually, mobile was sold to me, your lordship.
Not
And
that.
reside together, lordship, at the same building, your lordship. And there is a mobile is
No,
nothing. issue, your lordship.
when
3
Radha.
months before, your lordship. Radha is the main
No,
accused.
when Imdadul died.
In the trial on 28 October, your lordship. And before
when
3 months, I was staying at separate places of this incident.
and what is the
Police arrested
evidence
me from
when they
Srinagar.
stayed together?
My lord, in
3
the
months before of the incident, your lordship.
from the
As per
statement of the
forwarding
accused,
report.
my lord, from the statement of the accused, my lord, চিনাকি সূত্ৰে মই প্ৰিয়াংকীৰ লগত থাকিব লওঁ আৰু মই ৰিক্সা চলোৱা উপাৰ্জন কৰা টকাবোৰ প্ৰিয়ংকাৰ লগত জমা হয়। Here he has said that, my lord,
Since when you are in custody?
my only, my lord,
1st November.
26 days, my lord. And here, my lord, we have received the PM report, but FSL report not received, my lord. Here it was sent for chemical examination.
Not on that.
At the
My
required team.
There are injuries on the
40 year lordship.
body.
Hmm.
The question
My-
is why the present petitioner is implicated?
My lord,
Only because he stayed with the
my lord,
deceased.
Live
my lord.
together, your lordship.
When he stayed?
My
3
lord.
months
Before the
before, your lordship.
incident or 3 months ago?
3 months ago.
Now,
In
what is there
forwarding
in the
report-
case diary?
Forwarding report, during investigation, it has come to the light that Amdadul Islam Priyanka estate at house number 35, Islampur, Sanmari, in the house of Mafida Begum. And Amdadul Priyanka left her rented house 3 months ago, your lordship. Police started here.
Okay.
My lord. And another submission is in, my lord,
Last paragraph is number 14.
in the forwarding also it was reflected that there is a, my lord,
I'll live together, that's another equal. 3 months before she left, the petitioner left
with the victim, your lordship, and decided in another place, your lordship.
Or you
On
go through
working
the
purpose.
case diary, because if they stayed together 3 months ago,
my lord, my lord,
that may not be a ground for
my lord.
detention.
They have the mobile, my lord.
At
The
that time,
mobile has been recovered
Recovered from his possession, my lord. The mobile belongs to the my lord deceased man.
because they stayed together.
together, your
That may
lordship.
be the
That's why
different, but
mobile exchange,
mobile was
nothing.
Apart from recovery of mobile, is there anything? Is there any other material?
no, my lord.
No, mate.
My lord. In the forwarding, my lord, lordship, may I
At
please,
bottom,
my
your
lord?
lordship, page 14, your lordship.
Let me. According during revision, it is come to the light that Amdadul Islam Priyanka so and so, Sanmari, Makita Began, and Priyanka rented house 3 months ago. Amdadul Islam Priyanka and her boyfriend, namely Hamidul, stayed together before left the rented house. Hamidul Islam stolen away the mobile phone of Amarul Islam Priyanka and escaped from the place. Is that Amirul Islam tried to contact Hamidul Islam several times, but they quarreled each other over phone and also my lord. Pretend that if she tried to contact him, he will kill her, my lord. From the forwarding, my lord. It is my lord.
It is admitted they left her about 3 months before, your lordship, and live together. Then on mobile phone, your lordship, nothing. Police suspected that it is stolen. Actually, I take it from her, your lordship.
From
That
where
is
the body was recovered?
Sanmari area.
Engineering college.
Sanmari.
On
my lord.
2810.
It was in the big, my lord.
Whether postmortem report is there?
My lord, postmortem report is there, my lord.
What is,
Here the 10 injuries are here, my lord.
what is the time of the death?
My lord.
When since
Uh,
before
approximate time passed since date 12 to 24 hours before the
that
time.
means within 26, 27,
My lord.
he was killed.
My
He or
lord.
she was killed.
My lord.
But they stayed together only for
3 months ago.
No, my lord, that is, my lord, and they have been living together 3 months ago. They have left, but there may be come contact from
material.
my lord.
Except
My
from
lord.
Shiv Sagar, lordship.
Or you may do one thing.
My lord.
You can go through the case diary.
My lord.
If there is no material, there is no justification.
My lord.
In,
I have sent my lord not. I have checked my lord not to make and
no, I will not see.
My lord.
You point it out to me if there is any materials
My
are
lord.
there.
My
If you think that this material is relevant, I will consider it.
Hmm.
Otherwise, he will be
My lord.
allowed to go on bail.
My lord. My here submission that my lord, the investigation is initial stage, my lord. At this stage, my lord, two submission is that my lord, he is the boyfriend of the my lord deceased person, and another submission is that my lord, he has mobile which was stolen by the present petitioner. It was recovered. The mobile phone belongs to the my lord deceased man.
How can
It
say
was
that the
recovered
mobile was
from
stolen,
the
your lordship?
Okay, let him submit.
my lord.
Heard
My
Mr.
objection on that point, my lord.
Okay. Heard Mr. AAR Karim. Since when you are detained?
Lordship, on 1st November, your lordship. 01, even of 2023.
Heard Mr. AAR Karim, learned counsel for the petitioner. Also heard Mr. P. Sharma, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Hamidul Islam, who has been detained behind the bar since 1/11/2023 in connection with Chanmari PS case number 389/23 under section 302/201 of the Indian Penal Code. The gist of accusation against the present petitioner is that on 27/29 on 29/10/2023. What is the date of affair? On 29/10/2023.
29/10.
One Muhammad Romila Khatun had lodged an FIR before the officer in charge of Sanmari police station, inter alia, alleging that on 28/10/2023, the first informant came to know through TV news channels that someone has killed her son, namely Imdadul Islam alias Priyanka, and kept the dead body at Chanmari. It is alleged in the FIR that the son of the deceased, namely Imdadul, was working as first-time transgender along with another transgender, namely Radha, who used to mercilessly assault the son of the first informant. And it is further alleged in the FIR that about 2 months prior to the incident, the said Radha, within inverted comma, threatened the son of the first informant to kill him. Stop. Learned counsel for the petitioner submits that the petitioner was the friend of the deceased and he used to stay with the deceased. However, before 3 months, 3 months before the alleged incident, he had parted with the company of the deceased. It is further submitted that the petitioner is no way involved in the offense alleged in the FIR and he has been detained behind the bar for last 23 days. 23 days. Stop. On the other hand, learned additional public prosecutor has opposed the grant of bail to the present petitioner and has
At the initial stage, at the
on the ground that the investigation of the Chanmari PS case number 389/23 is at its initial stage. He has also produced the case diary of Chanmari PS case number 389/23 and has submitted that the present petitioner was the friend of the deceased and used to stay with the deceased in the same rented house. However, about 3 months ago, they left their rented house. It is further submitted by learned counsel for the learned additional public prosecutor that the present petitioner had stolen away the mobile phone of the deceased and has escaped and has fled away from who is Amdadul, that is deceased,
This is my
mobile phone of the deceased, and he
and recovered from the
after that there was a quarrel over telephone.
from the foreign.
And as the mobile phone of the deceased was recovered from the possession of the present petitioner, learned additional public prosecutor submits that there is every possibility of the present petitioner being involved in the alleged offense, and therefore he opposed the grant of bail to the present petitioner. I have considered the submissions of the learned counsel for both the sides and have perused the materials available on record, including the case diary of San Mary PS case number 389/2023. On perusal of the FIR, it is apparent that no allegation has been leveled against the present petitioner by the first informant, and specific allegations were leveled against one Radha. The only material against the present petitioner at this stage of investigation is that the mobile phone of the deceased has been recovered from the possession of the present petitioner. There are also materials in the case diary to show that the petitioner had parted company of the deceased much before the incident had occurred. Hence, at this stage of the investigation, there are not much incriminating evidence against the petitioner to justify his further detention, as he has already been detained behind the bar since last 23 days. Considering the above facts, the petitioner, namely Hamidul Islam, is hereby allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate, Kamrup Metro, with following of conditions. Number one, the petitioner shall appear before the investigating officer as and when so required by the investigating officer for the fair completion of the investigation, and shall cooperate in the investigation. The number two, the petitioner shall not directly or indirectly. With above observation, this bail application is thereby disposed of. I'll send back.
May it please, Your Honor. In this matter, there was an allegation last time by an endorsement in the city that despite obtaining an interim bail, I did not appear before the IO. My lord had perused the city on that day. My lord, I have filed an affidavit. This my colleague had taken on record. But I had been accompanied by one advocate from Jorhat, Gautam Bora. His affidavit also I have enclosed. And also, my lord, photographs with the metadata showing the date and time when I had appeared. If my lord comes to, and also the certified copy, if my lord comes to page 37, that is the certified copy which I had obtained, which lordship was pleased to reflect in last order dated 8th November. My lord, you will see the application number of the certified copy. This is 550295 of my lord, delivered on 25th of November 2022. This is a very photocopy of this same certified copy. My lord, was available.
Page?
My lord, page 37. Page 37 of the affidavit, my lord. I'm sorry. Oh, it's a running page number. Page 37 of the affidavit.
This is the order.
This is the lordship will see at the top, my lord, application number with the dates. This is the certified copy application number 550295. That is the application number. Application.
This certified copy was obtained by you.
It was obtained by me. I produced it at the time of my appearance, and this is available in the seat, which they said the last date. Thereafter, my lord may come to page 41 onwards. I have taken photographs. Both of us, we were accompanied by our father as well as our counsel at Jorhat, Mr. Gautam Bora. My lord, the photographs were taken. The metadata of the photograph is there, my lord. Lordship will see the date, November 29, 2022, 3:17 p.m. Next page, my lord, November 29, 2022, 4:20 p.m. Then 29, 2022, 4:21 p.m. Same, my lord, 4:23.
This data is known as metadata.
Metadata.
Automatically generated in the mobile phone.
Yes.
This cannot be manipulated.
It cannot be manipulated. Or, my lord, if someone is an expert, I don't know, my lord, if someone is an expert nowadays.
Okay. Otherwise, prima facie, it appears that you appear.
My lord, I also have annexed an affidavit of my colleague at Jorhat, my lord, from page 49. Page 50, my lord, may come to. These are of the two cases. Page 50. I'll read out, my lord. I am Gautam Bora, aged so and so. I'm a citizen.
So, the counsel from Jorhat accompanied the petitioner
Yes, my
to the
police station.
police station.
And in his presence, a certified copy was handed over to the IO.
Who is the IO? What is the name?
The name of the IO, Lokhinandan Bora at that point of time. And the present IO is someone else. My lord, this is, if I may humbly submit, this is criminal contempt. If my lord takes up the contempt of courts act, 2C, my lord. Of course, I cannot file a criminal contempt case. If suo motu it is taken up, it is up to lordship, my lord. 2C, if I may read out, my lord. Criminal contempt means the publication, whether by words spoken, written, or by signs or by visible representation or otherwise, of any matter or the doing of any act or any other act whatsoever, which one scandalizes or tends to scandalize or lowers or tends to lower the authority of any court. 2 and 3 are important, my lord. Prejudices or interferes or tends to interfere with the due course of judicial proceeding. Or 3, interferes or tends to interfere with or obstruct or tends to obstruct the administration of that in any matter. My lord, this is happening not only in this case, my lord.
No, whether you met the IO.
I met that.
What is the observation?
My lord, there is no such endorsement, lordship, that they appeared before the investigating officer pursuant to the interim direction dated 23/11/2023. As per the my lord update of the case diary, lordship, they have appeared on 9/11/2023, lordship.
But the materials produced by the
Yes, but that material I cannot say, lordship, whether my lord it is my lord taken by them, how it was taken and how they have produced it before this honorable court. Because my lord, nowadays everything can be my lord can be manipulated and my lord modified, lordship. That I have nothing to say, lordship. I am not accusing anybody, lordship, but I am only submitting from the case diary, lordship, that when they have appeared, lordship.
My lord, what about the existence of the certified copy? The same copy which I
how you will justify that?
He's lying with his teeth, my lord.
Anyway, lordship, now they have
Not
appeared.
my friend, my friend. Not my friend. My friend will not lie. But the IO, my lord, something needs to be done, my lord. My lord knows the reasons why they do not make these endorsements. It's common knowledge amongst us, my lord, why they do not. Not only in this case, many cases.
Who is the IO?
That time, Lokhinandan Bora.
Before whom you have appeared?
Lokhinandan Bora. In fact, my lord, in the other case, though there was no such direction in item 33, my lord, though there was no such direction.
Now the IO is a different IO.
Now is my lord one Ranjan Soikia, lordship. Well, they have appeared before my lord Ranjan Soikia and he has recorded their statement, lordship.
No, that was later on. Now
That was later on,
this
lordship. Earlier, lordship,
anticipatory
Lokhinandan.
bail application is as regards the question of making the anticipatory bail order absolute. That is there. There is no reason to disbelieve them because
My lord.
Because you have the photocopy.
My lord.
The question is the communication gap. You have spoken to the present IO.
No, my lord, I have not spoken to the present IO. I have lordship gone to the case diary, lordship. Because I have also found that the interim protection was granted on 23/11/2022 and they were directed to appear within 7 days, lordship. But I have not found their statement, lordship, when I have gone to the case diary. But in the my lord, last part of the case diary, I have found that they have appeared on 9/11/2023 and their statement recorded. So I am submitting whatever I have submitted, I am submitting from the my lord.
That is pursuant to the last order, 8/11 order. But my lord, the other case, my lord, item 33.
No, before we go to, let us finish this one.
It's out of the same case. The existence of the certified copy, my lord, belies everything. It was produced on the last. Belies the statement that I had found.
Okay, no. No, I am on the question whether something has been misrepresented before this court.
It has been. It has
Nothing has been misrepresented because the on the last occasion, public prosecutor submitted from the diary only.
Yes.
Whether you were directed to speak to the IO on last
My lord,
occasion, no,
last occasion I did not appear in this case, Lordship.
no, there is no such direction.
There's no.
So there is no such statement given before this court that they have not appeared.
He was speaking from the endorsement.
From the
No,
endorsement that
endorsement.
it appears that their statement is not available.
My lord, the endorsement, the submission, if I remember correctly, my lord, was we have not reviewed. Despite the interim order. That was the
Because of not finding their statement in the, it is not a case where the IO has informed the PP wrongly.
My lord, the endorsement may be read, my lord. What was the endorsement?
Endorsement of the present IO,
Present IO, yes.
because there is a change in the IO.
Yes, Lordship. The present IO, I am, my lord, referring to. And I have been informed, my lord, that the questions which were put, my lord, were exactly the same. This time when we appeared, the same exact questions were asked on the previous occasion when we had appeared on 29th of November.
No, before whom you have appeared?
Before the previous IO. And this time before the new IO, but the questions are exactly the same.
What question?
The questions put to me, you know, put to the put to the applicants by the IO. Both the IOs, while recording the statement, both the IOs answer exact same questions.
Now, how it is relevant?
My lord, most probably the previous statement was recorded, it was kept there. It
No,
might
but
not
it
have
is,
been
it
said.
is not there.
No, it might not have been said. That is what
That is an assumption on
it's an assumption.
heard Mr. P.D. Nair, learned counsel for the petitioners. Also heard Mr. R.J. Borua, learned additional public prosecutor. By order dated 8/11/2023, learned additional public prosecutor was requested to seek instructions from the investigating officer. No, you have sent back the case diary after 8/11.
My lord, sent for updation. I mean, the order was. Yes, we have sent it, my lord.
Now the case diary.
Now we
before
have
you-
received the case diary along with a, my lord, forwarding letter, lordship, that is dated 2011-2000.
It is an updated.
Yes, updated.
Now their statement is there.
Yes.
What is the last word? From the investigating officer as to whether the present petitioner have appeared before the investigating officer or not. Learned public. On the other hand, the petitioner were allowed to submit an affidavit, additional affidavit, bringing on record the fact as regarding their appearance before the investigating officer in pursuant to the directions of this court. It appears from record that on 23/11/2022, both the petitioner, how many petitioners are there?
In item 32-2, in item 33-1.
Both the petitioners, namely Asfaq Khan and Iftikhar Khan, were allowed to go on interim anticipatory bail by this court, and learned counsel for the petitioner has submitted that in pursuant to the said direction, the petitioner had appeared before the investigating officer on
29.
on
29.
on 29 on on 29/11/2022, and their statements were, and they were also interrogated by the investigating officer, the then investigating officer, namely
Lakshminandan.
Lakshminandan Bora. And in support of the said contention, learned additional public prosecutor has learned counsel for the petitioner has submitted the has pointed towards the additional affidavit where the said statement is made on oath by the present petitioner. It is also pointed out by the learned counsel for the petitioner that after passing of the order dated 23/11/2022 by this court, the petitioners applied for certified copy of the said order by filing application number 550295 dated 25/11/2022, and in pursuant to the said application, the certified copy was furnished to them by the registry of this court. Learned counsel for the petitioner has submitted that the copy of the said certified copy, a photocopy of the said certified copy was furnished to the investigating officer by the petitioners on their appearance before them on 29/11/2022.
He submitted the certificate.
Certified copy. Instead of photocopy, certified copy. Learned counsel for the petitioner has also annexed, along with this, his evidence, his additional affidavit as annexure number A2, A3, and 4, certain snapshots wherein the petitioners appears to be waiting in a police station, and the metadata and shown in the said photographs shows the time as 3:17 p.m. on November 29, 2022. Stop. On the other hand, learned counsel for the learned additional public prosecutor has submitted that the though initially there was no statement of the petitioners found in the case diary, however, later on which date it was recorded?
9/11.
On 9/11/2023, the statement of the present petitioners have been recorded by the present investigating officer, namely
Ranjan Soikia.
Ranjan Soikia. Can it be found out when this was changed?
My lord.
When the investigating officer?
Yes, Lord.
As it appears from the case diary that the certified copy which was obtained of the order dated 23/11/2022, which was obtained by the present petitioner, is available. A copy of same is available in the case diary, and as the petitioners have appeared before the investigating officer again on 9/11/2023.
So this officer took search from 21/7. Present officer. To 23.
So you may try to inquire from the earlier investigating. I am disposing of this case with a request to you that whether they appeared before the earlier investigating officer. This may happen that they appeared, the statement might not have been recorded. But as because you are making submissions before High Court, wrong information should not be given to the public prosecutor by the IO. When IO seeks an information, it is on behalf of High Court. So if intentionally they intend to give wrong information, that may entail severe consequence. This has to be told to the earlier IO. What was the last? Line in it. It appears that the present petitioners have complied with the directions of this court and have cooperated with the investigating officer in pursuant to the cooperated with the investigating officer. Stop. As the present petitioners have cooperated with the investigation, their custodial detention does not appear to be necessary for fair completion of the investigation. In view of above, the interim anticipatory bail granted to the present petitioners by order dated 23/11/2022 is hereby made absolute with conditions number 3 and 4, 2 and 3 attached to the said order remaining intact.
But the council has also filed an, I have submitted an, that is the X. Page 50.
Okay.
That may also be.
Ek line agotuma bole. I have also learned counsel for the petitioner has also pointed towards an affidavit submitted by the counsel of the petitioner at Jorhat, namely Gautam Bora, who had accompanied the petitioners to the police station on 29/11/2022. He line to Majot tomorrow. If you try to contact the OC of the concerned police station. Take the phone number of the investigating officer, earlier investigating officer. Intimate him about what has happened. And then inform me about the
whether they have actually appeared or not.
In my chamber as per your convenience.
Basically, my lord, no accused person will dare to, my lord, not appear before the IO if the interim protection is granted. This is a case of 302, lordship. Otherwise, they will appear, lordship.
Yes.
But I'm submitting only from the record, lordship.
Yes, no, there may be sometime what may happen that IOs are overburdened.
Yes.
They might not have recorded this statement then and there. And this might have remained as it is, and there is a change of IO. That may also happen.
It may happen. Malord, if I may, Malord, looking at the other cases as well, if the process is streamlined, if some guidelines are given, and in each of those guidelines, my lord should entail severe. Because otherwise, it's a question of liberty. I'm speaking from the side of the accused persons who are granted bail, but also, my lord, as an officer of the court. Some, my lord, if furnishing false information to the court, it may not be false because he did not find it on
In
record.
this case, we cannot compare.
No, not on this, my lord. I'm just making a
Let
submission.
such matter come
My lord.
come up before court.
My
Let
lord.
such an occasion come.
My lord. My lord, the other matter,
Other case,
my lord, here I do not have a this certified copy, photocopy. I have annexed, my lord, at page 30.
it is in regarding the
Same.
here also they have appeared.
I have appeared, my lord. The
My
same
lord,
affidavit
on
is
the
there.
same day, Lordship, he also appeared, Lordship, and his statements were recorded on the same day, Lordship.
Heard Mr. P.D. Nair, learned counsel for the petitioner. Also heard Mr. R.J. Burwa, learned additional public prosecutor. Learned counsel for the petitioner has submitted that by order dated 8/8/2022, the petitioner, namely, what is the name?
My lord, Mansoor Ali alias Papun.
Petitioner, namely Mansoor Ali alias Papul was allowed to go on interim anticipatory bail by this court and in pursuant to the directions of this court, the petitioner had appeared before the investigating officer. Learned additional public prosecutor has, on the other hand, produced the case diary of Jorhat PS case number 635/2022 and has submitted that from the case diary, it appears that on 9/11/2023, the petitioner has appeared before the investigating officer. Considering the fact that the petitioner has complied with the directions of this court and has appeared before the investigating officer, and his statements are recorded, and his statement has also been recorded under section 161 of CRPC, the interim anticipatory bail granted to the above named petitioner by order dated 8/8/2022 is hereby made absolute, with condition number 2 attached to the said order remaining intact. With above observation, this anticipatory bail application is thereby disposed of. Send back the case.
Here also the affidavit of the counsel.
That is not required. In this case, I am not going into the.
Deeply obliged.
My lord, 34 charges submitted, Lordship.
Hello, in this case, my lord, charge sheet has been submitted, my lord.
You are on interim.
I'm in.
You appeared before IO.
I appear before the IO, my lord, in this case, my lord, and my statement has been recorded, my lord. And subsequently, charge sheet has been submitted.
Heard Mr. N.N.B. Chaudhary, learned counsel for the petitioner. Also heard Mr. R.J. Burwa, learned additional public prosecutor. Learned counsel for the petitioner has submitted that by order dated 1/3/2023, the petitioner, namely Diganto Dole, was allowed to go on interim anticipatory bail by this court, and in pursuant to the directions of this court, he had appeared before the investigating officer and his statement were also recorded. On the other hand, learned additional public prosecutor has submitted that though the case diary was called for, however, in the meanwhile, the investigating officer has laid the charge sheet bearing charge sheet number
75/2023, dated 30/8/2023, 30 August.
In view of the fact of the laying of the charge sheet as well as
Someone has been received, my lord. Yesterday, I got a copy.
as well as in view of the submissions made by learned counsel for the petitioner, the interim anticipatory bail granted to the present petitioner, above named petitioner, is hereby made absolute. And this bail application is hereby.
35 also charges submitted, Lordship.
No, please, not. The interim is their lordship and they appear to the police.
Heard Mr. F. Hawk, learned counsel for the petitioner, Also heard Mr. R.J. Burwal, an additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid bearing charge sheet number
204/2023, dated 27/8/2023.
On the other hand, learned counsel for the petitioner has submitted that by order dated 24/8/2023, the petitioner was granted interim anticipatory bail, and in pursuant to the directions of this court, he had appeared before the investigating officer and has cooperated in the investigation. Considering the fact that the petitioner has, considering the submissions made by learned counsel for the petitioner, the interim anticipatory bail granted to the above named petitioner by order dated 24/8/23 is thereby made absolute, with condition number 1, 2, and 3 attached to the said order remaining intact. With above observation, the anticipatory bail application is thereby disposed of.
Blush.
Your Lordship. Under 438 application, your Lord, the allegations against the petitioners are 306 abatement. And your Lordship will find the petition number 1, that during the pendency of this bail application, my Lord, the petition number 1 has been arrested, my Lord. And my Lord, your Lordship has granted bail after the arrest, my Lord. And next are 2 and 3 are now seeking for pre-arrest bail. Your Lordship will kindly during the pendency of this petition
Who
number.
has died?
No,
Who has
a boy, what has happened, a boy has stolen a mobile phone from the house of petition number 2. Then he has been scrawled by, as per the FIR, is by 3. And he committed suicide on the next day. And the allegation is this, that because of that, he has committed suicide. Because of mental agony and Lordship, my Lord, out of mental harassment, Lordship. That was an allegation is this, Lord, he committed suicide. We have received the postmortem report, Lordship, with the case of drowning, Lordship, anti-mortal drowning, and my Lord, otherwise, Lordship, some of the other witnesses, they have said, Lordship, that they have accused this person, Lordship, that you have stolen our mobile phone, so you finally returned it. So that is the only thing, that mobile has been stolen away, my Lord. Let them cooperate, Lordship, otherwise.
Heard Mr. P. Bora, learned senior counsel, assisted by Mr. R. Hawk, learned counsel for the petitioner. Also heard Mr. R.J. Burwal, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by 3 petitioners, namely Nakib Ali alias Nakibuddin, number 2 Moromi Begum alias Jasmine Begum, and Muhammad Ismail Ali, who are apprehending their arrest in connection with Bahata Charali PS case number 215/23 under section 306/34 of the Indian Penal Code. Learned senior counsel for the petitioner has submitted that during pendency of this anticipatory bail application, the petitioner number 1 was arrested in connection with the Bahata Charali PS case number 215/23, and he was also allowed to go on bail by this court by order dated 17/11/2023, passed in bail application number 4041/2023. Stop. The accusation against the present petitioners is that on On 15/7/2023, one Farida Begum had lodged an FIR before the officer in charge of Baihata Sareli police station, inter alia, alleging that her son Mirazul Ali was accused of stealing mobile phone of petitioner number 1 and was falsely accused of stealing mobile phone of petitioner number 1 and for the said accusation he was mentally and physically harassed by the petitioner. Thereafter, the son of the first informant, under mental pressure and agony, committed suicide by jumping into river Bornadi. Learned senior counsel for the petitioner has submitted that there is no aid or abatement of suicide on the part of the suicide of the deceased on the part of the present petitioner. Learned senior counsel has also submitted that in the meanwhile, the I'm taking what
Mike.
aid or abatement present petitioner. On the other hand, learned additional public prosecutor has produced the case diary of the Baihata Sareli PS case number 215/23 and has submitted that. What is your submission?
My submission is that, Lord, if there are, my lord, statement of the witnesses that, my lord, he was mentally harassed that to return the mobile phone, although
That
he has
the-
not stolen the mobile phone.
That the deceased was mentally harassed by the present petitioners
Petitioners, my lord, yes.
to return the mobile phone,
And they have accused, Lord.
which they have accused which they accused the deceased to have stolen from them.
My lord.
I have considered the submissions of learned counsel for the both the sides and have gone through the materials on record, including the case diary of Baihata Sareli PS case number 215/2023. Considering the fact, considering the fact that the investigating officer has in the meanwhile recorded the statement of witnesses who are relevant witnesses under section 161 CRPC. Also considering the fact that one of the co-accused who was arrested in this case in connection with the Baihata Sareli PS case number 215/2023 has already been granted bail by this court. The custodial detention of the present petitioners does not appear to be necessary if they otherwise cooperate with the investigating officer. In view of above, the petitioners, namely Moromi Begum, alias Jasmine Begum, and Ismail Ali, are hereby directed to appear before the investigating officer of Baihata Charity PS case number 215/2023 within 10 days from the date of this order and cooperate in the investigation. If they do so within the stipulated period of time, in the event of their arrest in connection with Baihata Charity PS case number 215/23, they shall be allowed to go on bail of rupees 30,000 with one surety of like amount subject to the satisfaction of the arresting authority. With the above observation, this anticipatory bail application is thereby sent back.
My lord, in this case, item number 37, my lord, the petitioners are the family members of the appointment accused persons, my lord.
My lord, in this case, Lordship, we have returned the case diary for up and call for the update case diary, Lordship.
My lord,
That we have not received, my lord.
they, my lord, they are not in interim, my lord, and in the appointment accused persons are in interim, my lord. And another interesting thing is another brother of the appointment accused persons has been granted anticipatory bail by the session judge, Vijay, my lord. I have the copy. Then Chutral is the brother of the appointment accused person. He has been granted anticipatory bail, my lord.
And if I named accused,
He is also granted interim bail, my lord, by the Supreme Court, my lord. This is the next statement, my lord. That is, this is the order, my lord.
then why your
My lord, we are the family member, my lord.
why your prayer is not, you have not approached?
No, our prayer is separate petition, my lord. Our one is separate petition.
No, okay. The FI named by
That
other,
is FIR, the lordship will find the FIR Act is 9, my lord. Subhash Sutradhar and Pradeep Sutradhar.
okay, let them also appear if they named accused.
Lordship,
What is the allegation?
Lordship, allegations that in the
Assault.
in Manusha Murti Visarjan, my lord, immersion program, one quarrel took place, my lord, and thereafter this incident was took place. My lord.
What incident?
My lord, the fighting, my lord. Lordship will find it at page 10, my lord. Relevant portion is at page 10, starts from page 9. May I read, my lord?
No, not necessarily.
Then Lordship kindly.
Heard Mr. B. Chanda,
my lord,
learned counsel for the petitioner. Also heard Mr. R. J. Borwa, learned additional public prosecutor, who submits that though the case diary was called for, however, same has not been received.
No, my lord.
No,
We received
though
the
the
case diary, but
though
it
the
was,
case diary was earlier received,
my lord,
however, same was not updated
my lord,
and it was sent back for updation
my lord.
and they have not, and same has not yet been received. It also appears from record that
No, I am sorry, Lordship. In this case, victim died, Lordship. That is why the case diary along with the postmortem report was concluded. That has succumbed to his injury.
it also appears from record that today is the 5th date fixed for perusal of the case diary. On the other hand, learned counsel for the petitioner submits that a coordinate bench of this court has already granted interim protection to one of the FIR named accused, namely Subhash Sutradhar.
my lord.
Subhash Sutradhar. The accusation in this case is that on 24/8/2023, one Shri Shankar Roy had lodged an FIR before the officer in charge of Hojai Police Station, inter alia, alleging that on 28 2023, during this is Durga Puja.
Monosha Puja, my goddess Monosha Ma.
During the immersion ceremony of goddess, immersion ceremony of Monasha Puja
Right.
on where it was
It was Tibbari Durga Mandir Pond, my lord.
near Shibari Durga Mandir Pond,
Hojai.
Hojai. A quarrel ensued between the accused persons named in the FIR as well as son of the present petitioner, son of the informant. It is to be noted that two accused persons, namely Subhas Sutradhar, within bracket, who has already been granted bail by a coordinate bench of this court, bracket close, and Pradeep Sutradhar have been named in the FIR filed by the informant. Stop. It is alleged in the FIR that the son of the informant was beaten up by the FIR named accused persons, causing injuries on his person. Later on, he was the son of the first informant was taken to the hospital, and he was admitted in the ICU at the time of lodging of the FIR by the first informant. Learned additional public prosecutor has submitted that in the meanwhile, the son of the first informant has succumbed to his injury, and section 302 has been added to this case. Stop. Though this case involves offense under section 302 of the Indian Penal Code, however, considering the fact that the present petitioners are not named in the FIR and named in the FIR, and the FIR name, one of the FIR named accused has already been granted bail by the petitioner, by this court, the petitioners, namely so and so, all petitioners, one of the petitioner is arrested.
Two petitioners, except petitioner number 6 and 7.
Petitioners except 6 and 7.
6 and 7.
6 and 7. Petitioner, namely so and so, are hereby directed to appear before the whether case diary would be required.
Yes, my lord, let the case diary come.
Appear
Let them
before the
appear and my lord,
investigating officer of Hojai PS case number 377/2023 and cooperate in the investigation. Stop. If they do so within the stipulated period of time, in the event of their arrest in connection with Hojai PS case number 377/23, they shall be allowed to go on interim anticipatory bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority. Let the case diary be called for fixing.
My lord, month of 11 December. 11th.
Fixing
12 December.
Fixing 12 December for case diary.
I'm for item number 38. I'm already on interim.
Same matter.
Same matter, Mr. I'm already on interim matter.
Same matter.
Heard Mr. P. Bora,
D. Bora.
D. Bora, learned counsel for the petitioner. Also heard Mr. R. J. Borua, learned additional public prosecutor who prays for another date for allowing the prays for another date for producing the case diary. Prayer is allowed. Let this matter be listed on 12th of December. The interim order shall continue till
Obligation.
Please, Your Lordship, I am appearing on behalf of Mr. J. Gautam, Lordship. He is the counsel in this case. Lordship, he has some difficulty today, Lordship. The matter may kindly be taken up next with us.
heard Miss
P. Sharma, Lordship.
heard Miss P. Sharma, learned counsel for the petitioner
No,
who prays for an adjournment on the ground of the personal difficulty of the conducting counsel, Mr. J. Gautam. Considering the grounds mentioned by the petitioner, learned counsel, the prayer is allowed. Let this matter be listed again on
29th, Lordship.
6/12. 6/12.
Lordship, interim
The interim order shall continue till next week.
obliged, Lordship.
Here is page number 10 here. 438 application petitions are on interim.
With the case diary has
Lordship, CD is not available.
heard Mr.
R.A. Choudhury.
R. A. Chaudhary, learned counsel for the petitioner. Also heard Ms. S. H. Vora, who prays for another date for producing the case diary. Prayer is allowed. Let this matter be listed again on
Lordship, can it be on 4th of December?
4th of December. The interim order shall continue till interim
Can
is
it be later date may be given, not the
Yes.
reason.
because otherwise a lot of cases are listed.
Yes, Lordship, then on 18, Lordship.
18
Yes, Lordship.
Interim order may be.
interim order shall continue till
Obliged.
Please, Your Lordship. The petitioner is in this interim, Your Lordship. Case 10 is the FIR, Your Lordship. Needs FIR before the IR. Case 10 is the FIR.
43 CD is there.
CD is there, Lordship. Statement recorded. Appear before the IR.
Heard Mr. S. Islam, learned counsel for the petitioner. Also heard Ms. S. H. Vora, learned additional public prosecutor. Learned counsel for the petitioner has submitted that by order dated 31/10/2000, the petitioner was allowed to go on interim anticipatory bail by this court, and in pursuant to the directions of this court, the petitioner has cooperated, has appeared before the investigating officer and has cooperated in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Tinisukia PS case number 573/23 and has submitted that the petitioner has appeared before the investigating officer and his statement under section 161 CRPC has already been recorded. Considering the fact that the petitioner has cooperated in the investigation, the interim anticipatory bail granted to the petitioner by order dated 31/10/2023 is hereby made absolute with condition number 1, 2, and 3 attached to the said order remaining intact.
Obliged.
With above observation, this anticipatory bail application is disposed of. Send back the case.
Obliged.
Before my learned friend starts, my lord, on last occasion, your lordship heard him for some time, and my lord, it is part heard. Now, my lord, I have received the case diary. This is a voluminous, my lord.
I need some time to go through it, and I need also some instructions from the Milord.
I'm also not well.
It's okay.
Or could it be taken up?
Only
the-
thing is, my lord, from fifth, that constitution bench is there in Supreme Court. I'll be there. So let it be on the 18th or that week commencing if your lordship is available.
December. Okay.
It will be commencing from 18th. Any dates convenient for lord.
My lord.
This is that SP matter.
Yes.
Yes, my lord.
Okay.
Actually, I was supposed to place some judgment and subject to what my learned friend says, they gave the reply.
Okay.
I have received the case, Milord. I have also gone through some, but I need some clarifications
Okay,
from the
go through it.
Yes, yeah, and it will take some time.
Third,
Milord.
Miss-
Could it be taken up on 21st? 21st of December?
21st.
21st of December.
Heard Mr. K. N. Chaudhary, Learned Senior Counsel, assisted by Mr. T. Deori, Learned Counsel for the petitioner. Also heard Mr. B. Sharma, Learned Additional Public Prosecutor, who submits that though the case diary has been received, however, since it is a voluminous one, he needs some time to go through it and prepare for the hearing. The prayer is allowed. Let this case be listed again on 21st of
21st of
On 19th.
19th.
on 19th of December
For further hearing, madam.
for
In any case, I think it is part heard, no?
It is already part heard. No, it is not
shown
written as part
heard.
heard, but
Or lordship can show for further hearing, then further.
for further hearing. Your lordship has already recorded that he has been heard, and hearing could not be concluded.
Therefore, for further hearing.
Therefore, further hearing.
okay for further hearing.
Or lordship can treat it as shown as part heard.
Because
Yes,
if
no,
experience with part heard is not very good.
So then it will be parallel for further hearing. No, otherwise, my lord-
Basically, it is
no,
part heard,
actually,
my lord.
part heard, my lord,
Okay,
lordship
let
go
it be shown as part
Part
heard,
heard, yes.
part heard on 21,
Well.
12,
Deep on 19th.
on 19th.
Obviously.
Yeah, yeah.
Aruketa.
May I please? Lordship, we have filed this criminal appeal, Lordship. Whereby convicted the appellants, Lordship, two appellants before your Lordship, under section 12 of POCSO Act for 3 years, 354D for 3 years, and 2 years for 506 IPC. Lordship,
Mr. We are issuing notice calling for record.
Lordship, I am inside the jail, Lordship.
No. How
Appeal may be admitted, Lordship, and
How much punishment?
Lordship, 3 years, 3 years, 2 years, 8 years. 3 years for under section 12 of POCSO Act, 354D, 3 years.
We will
and-
hear
And Lordship, appeal may be admitted and my suspension may be considered, Lordship. We have also filed separate
After-
IA under section 380.
after receipt of the after receipt of the LCR.
No.
You are behind the jail now.
Yes, sir.
Since when?
Since the date of 7/11, Lordship.
So after receipt of the LCR, we
Lordship,
will
so far the merit of the case is, Lordship, this is the absolute case of acquittal, Lordship.
that we have to go.
For a moment, Lordship, for convicting an appellant, Lordship, for accused under section 12, Lordship, there must be physical contact, Lordship. But here in this case, there is no physical intention as well, no physical contact, Lordship. Absolutely, Lordship, forward judgment. Here, Lordship, for a moment, Lordship, kindly see the FIR, Lordship, FIR of the case, Lordship, case 17.
No, but notice to the victim or the guardian of the victim or parent has to go before your victim has to be heard. Only then the question of in POCSO matters, there is a
And the LCR may be called for.
Demand punishment.
whenever case,
6 years.
the appeal is admitted for.
One thing I am to submit, sir.
The LCR is here only in this court, my lord, with criminal appeal number 383. This is pending before this court, my lord.
7 years. 7 years.
Heard Mr.
D. Boram.
D. Bora, learned counsel for the appellant. Also heard Mr. D. Das, learned additional public prosecutor. This appeal has been registered. This appeal has been filed under section 374 within bracket 2 of the Code of Procedure, 1973 by the appellant Janardhan Kumar, impugning the judgment dated 13/9/2023 passed by learned Sessions Judge Lakhimpur in Sessions case number 30 within bracket NL/23, whereby the present appellant has been convicted under section 325 convicted under section 325 of the Indian Penal Code and has been sentenced to undergo rigorous imprisonment for 6 years and to pay a fine of
7 years, my lord, as it appears from the first title. 7 years, my lord.
6. They have mentioned it 6 years.
At phase 3. I'll check up the judgment, my lord. Phase 3, my lord, first title. Judgment.
Page 15.
No. 10. Increase judgment to 103. A1 में A2 हो जाना मैं 21 नंबर 3 हो जाना A2 manner sorry 6 years
6 years.
Case 179 he is A2 accused number 2 minute in the case but in first title he has mentioned wrongly 7 years
6 years and to pay a fine of rupees 10,000 in default of payment of fine to undergo simple imprisonment for 6 months. The appellant has also been convicted under section 120B of the Indian Penal Code and has been sentenced to undergo rigorous imprisonment for 6 months for this said offence and to pay a fine of rupees 5,000 and in default of payment of fine to undergo further imprisonment, simple imprisonment for 1 month. He has also been convicted under section 279 of the Indian Penal Code and has been sentenced to undergo rigorous imprisonment for 6 months and to pay a fine of rupees 1,000 and in default of payment of fine to undergo simple imprisonment for 15 days. The appellant has further been convicted under section 304 part 2 of the Indian Penal Code and has been sentenced to undergo rigorous imprisonment for 7 years and to pay a fine of 10,000 and in default of payment of fine to undergo further simple imprisonment for 6 months. Sentences are directed to be run concurrently. What is the
that is what I'm trying to find out, you know. Perhaps not mentioned.
issue?
Concurrent and consecutive date mention कौन है?
It is not. Okay. Issue notice to the respondents. Since an additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. However, as regards respondent number 2 is concerned, the petitioner, the appellant shall take steps for issuance of notice on respondent number 2 by registered post with AD within 3 days from the date of this order, returnable on. When is the other case fixed?
Other case, I will dispose of minor. The main case is pending.
Returnable after 3.
Lordship, can it be on this Tuesday, madam?
No.
Because in the other case, the respondent has already appeared. That is it.
This Tuesday
This is-
it is not possible.
Because the LCR is there only in the court. Otherwise, my lord, on Thursday, my lord.
Thursday যদি পারে নাকি?
Other co-accused is granted bail, my lord. That's why I'm praying. With criminal appeal number 383, my lord.
No, where is your eye?
Mama is here. I is for
Yes.
suspension of sentence, my lord.
No, let this. We will list IA
Yes,
on
IA.
Thursday.
Yes.
Let this matter be listed again after 4 weeks. Along with the
Criminal appeal number
criminal appeal number.
383.
তোমার order copy তো আছে নাকি?
No.
Bail order copy তো আছে হাইকোর্টে।
No, you make that
Yeah.
clear later on.
Let him furnish the copy of the co-accused bail order. Then he will consider on Thursday.
Yes, my. The IA may be called for my only I. Main case remain pending.
The I may be listed
On Thursday, my.
and otherwise he has
Other has gone for
alleged
bail,
them
my.
lot evidence, copy of evidence.
Yes, sir. Only I may be listed, my.
After 4 weeks. again. In IA. After 4 weeks. In IA, right, this interlocutory application has been registered on filing on of an application under section 389 of the Code of Criminal Procedure by the applicant Janardhan Kaur, praying for suspension of the sentence which was imposed on the present applicant by the judgment dated 13/9/2023, passed in Sessions Case number 30 within bracket NL/2023 by learned Sessions Judge Lakhimpur, North Lakhimpur. The said judgment has been impugned by the present applicant by filing a connected appeal which has been registered as criminal appeal number 491/2023. Issue notice to the respondent.
That's it.
The bail order in IA, my lord.
No, we are not going to that. We are issuing notice. You produce the bail order on yourself of the co-accused, co-convict.
We have already elected. We have
Okay,
elected
then
I.
we will see on the next day.
On Thursday,
my lord. Only the IA, my. Rest, it remains.
Let the notices, and what will happen to the notice to the opposite party?
They have already received, my lord, the other co-accused. It
But
is
bail
already-
is concerned, it is between court and very problem. It's
Because they have already received.
matter of
by the
liberty
other
without.
accused person.
No, liberty curtails after conviction. There has to be some reason, strong reason after conviction.
Let his IAB examined on Thursday.
Issue
Yes, my-
notice to the respondent since issue notice to the opposite party since the learned additional public prosecutor has appeared for the respondent number one. No formal notice need to be issued to the respondent number one. As the let us give a week at least.
My lord.
Will he not take steps on respondent number two?
Yes, he will take steps regarding the appeal memo.
And in IA,
IA, my lord, that is.
he has
I leave to your lordship as your lordship pleases, my lord.
My lord, will take steps in the main case, my lord. Criminal appeal.
Because so far
Consider, my
IA
lord.
is
This
concerned,
for
bail
bail
is
only.
concerned, now he is under custody, he is under judicial custody now. Court's custody. So,
same logic is applicable in appeal also. If you make such a step, let him take step. We will fix this matter after a week so that a reasonable time is given, at least for service of notice.
Yes.
Right, it's typical, my lord. Otherwise, justice service. Otherwise, we can serve because it will take another some 2 weeks, my lord. Like
So it has to become after. It has to be listed after.
otherwise, my lord, can be on Friday, my. We'll try, my. The service may be completed.
How will you try?
Because this is IA, my lord. The COIC is already on days.
No, you have come late to this
Yes,
court.
that is true, my
and
lord.
you are in a hurry.
Yes, my lord. 2 days before finishing the period, my lord.
He is in jail due to his.
Yes, my. COIC is already the
Before.
prime accused, in fact, my.
Only because co-accused are released, you want everything to
basically
come in
inform
line.
This petitioner, my lord, they have
Issue
engaged us
notice
late.
to the petitioner shall, the applicant shall take steps for issuance of notice on respondent number 2 by registered post with ID returnable on give a date
6/12.
6/12. Let this matter be listed again on 6/12.
IA, my lord.
I on 6/12.
Can it be on 30, my lord, November?
No, it cannot. Because service, you have made the
Because if otherwise, can be on 4th of December, kindly. 4th of December.
okay, fourth of
Deeply ordered.
$45. None appears.
Non-appearance.
None appears for petition. Let this matter be listed after 2 weeks.
Not.
Happy to know. So I'm a legal aid counsel out here. Here a report was called from the jail authorities regarding the period undergone by him in custody. And so far my instruction goes, Lordship, that
Who is appearing for?
Lordship, it's a jail appeal.
Okay.
Lordship, here what has happened, he has been convicted under 306 for a period of 10 years. And my instruction goes, Lordship, that he is serving sentence for around 5 years, 8 months. So in that regard, Lordship, already a report has been called from the jail authority. And as per the direction of NALSA, Lordship, we have filed one IA for suspension of sentence. Earlier, what happened, Lordship?
You are amicus curiae.
I am a legal aid counsel.
Okay.
Earlier, what happened, Lordship, in all jail appeals, as your Lordship knows, there was no such filing of 389. Subsequently, NALSA came up with a direction that in all jail appeal, 389 petition for suspension of sentence and for enlarging the convict to go on bail, that was to be filed. So accordingly, we have filed. But prosecution so far record says Lordship is yet to file their objection. Here, Lordship, what has happened, Lordship will kindly see. Here, there was one DW, and DW is the eyewitness, he was the son. In the paper book, Lordship will find in page number 32, Lordship. So far, just for the bail is concerned, Lordship, I am making my submission. Other witnesses were the close relative of the victim, but DW1, Lordship, he was the only person present as an eyewitness during the incident. And he said that his mother has committed suicide. Okay.
No, but this report has not yet arrived. That how long he has been.
He was
Because
told,
if
Lordship,
it,
in fact,
if he has,
I had an instruction from the Guwahati High Court Legal Aid Committee that report has come. Whether it's on record or not, that I don't know.
go through the report.
Yes.
Go through the record.
But,
We will
I was
see.
instructed that he is there from 5 years, 8 months.
So if he is more than 5 years, you may get some benefit.
Lordship, that is why I'm pressing that. And otherwise also, if your Lordship may kindly have a look, Lordship, he was arrested on the very date of the FI being lodged. And the FI was lodged on 9409.
Otherwise, it is a 302 case.
No, 306.
306.
306, 10 years he has been convicted.
And as per
For,
section,
for abatement to suicide. That is the only allegation against him. Although there was some allegation of dowry demand, Lordship, but they could not prove that the death has been done within 7 years. So 304 part 2 was not attracted. So he has been convicted under 306 count for a period of 10 years. Now, Lordship, I am pressing
No,
upon
if he has completed 5 years,
5 years,
if-
8 months. That is my instruction.
if there is no hope of immediate hearing of the main appeal,
Lordship,
then he may be granted.
Lordship. So let the report come.
No, he says report is there.
Okay.
Now,
That
that
part
is,
I'm
that
not
is the
aware.
instruction from the Guwahati High Court Legal Aid Committee, Lord.
Go through the case, the record. We are fixing it in a
Can it be on 30, Lordship, 30 or 31? Because, Lordship, this matter has come up several times. And I was asked to
No, but
submit a
when
report also.
appeals are fixed in bail courts, so bail matters are to be taken up first, and number of
No, no,
cases.
I'm not on that. I'm not on that. Because it came up and it reached also. And on the last occasion, if I'm not wrong, this honorable court has called for the report. And I'm not on whether it is taken up fast or that is not the.
No, the last order shows that the state respondent has yet to file
Their
an
Objection. So now, as per section 389, subsection 2 of CRPC, Lordship, there is a mandate. We have to, if the conviction is for 10 years, we have to file a written objection.
They can file. I have nothing to say regarding this. But it has been a long time. Prosecution has been taking time, Lord, for filing of their objection. If they file, let them file. If they do not file, let them say clearly that we do not intend to file. Because for their objection, Lord, a person is there.
Yeah.
And it will be fixed on 30, Lord, if it's convenient for this honorable court, 30 or
We have
1st of
In
December.
fact, Lordship, the record is not before me. It's,
go through the report when it can be picked.
30 or 1st of December, Lord, I can be happy of that. 1st of December.
Third, Mr. A. Bhattacharya, learned counsel
Everybody
for
go.
the learned legal aid counsel
maybe the
for the
market will
appellant,
ignore it.
applicant. Also heard Ms. S.H. Bora, who prays for some more time for filing objection against the interlocutory application filed by the
No, no.
applicant for suspension of the sentence during the pendency of the connected criminal appeal. Learned counsel for the appellant has submitted that earlier by this court had directed the superintendent of the district jail.
But if that report has not been called for, that report may kindly be called for. Because we are in confusion why I'm saying, Lordship. As per the FIR, Lordship, it was a 949, and since that day he has been arrested. Subsequently, if he has been released on bail, there's nothing. And Lordship, if from that day he is arrested, Lordship, then his period of 10 years is already complete. 9/4/2009, Lordship. And judgment in this matter, Lordship, was, that is why Lordship, report was called for, Lordship. Judgment was passed, Lordship.
What was
I'm actually sorry, Lordship, I interpreted in the report. Judgment, Lordship, was passed, Lordship, on
now of the district jail for an information as regards the period of detention already undergone by the present applicant. However, it appears that the report has not yet been received by this court.
Can a reminder be sent?
Issue reminder for the report as regards the period of detention already undergone by the present applicant from the superintendent of district jail Gorpeta. The registry to take steps for issuing the reminder. Let this case be listed again on
10 days, then it will take some time to 8/12.
8/12.
Development.
In the meanwhile, the
Prosecution, if they desire, they can
prosecution
file
may file an objection to the prayer for suspension of sentence if it desires to.
Lordship, a copy may be furnished to us.
Lordship, I will give a copy. Paper book, my sister is saying she is not having, I will give a copy right now.
Lordship,
I will give a copy.
obliged.
In this case, step has already been taken. For respond number 2.
But whether service
Respondent's name has not been shown in the court list.
but office note shows that you have not taken steps.
We have taken on 23 left.
Heard Miss
D. Datta.
P.
D. Datta.
D. Datta, learned counsel for the petitioner. Also heard Miss S.H. Gora. Though the office note dated 22/11/2023 shows that the petitioner has not yet taken steps for issuance of notice on the respondent number 2. However, learned counsel for the petitioner has submitted that the petitioner has taken the steps for issuance of the notice on respondent number 2 on
23 left.
23/11/2023. Hence, awaits service report on respondent. Let this matter be listed after. Review.
In this matter, we're struggling with the service to be made on the restaurant number 2.
Could you find?
I have searched for that regarding the justice servicing, more particularly in criminal case. But although there is no specific mention, but there is no bar also. I have not found it.
Where is the provision for justice service?
High Court rules justice services pertains to civil procedure code. There is a provision. But High Court rules, I may be lacking in searching, but so far I have searched.
In High Court rules, There is
I have not found any terminology as the
unless you convince this court, we have to.
But can it be done like this? The case is still pending the learned trial court, additional session that's Chief Sagar. Can the service be made through the learned trial? That can be done. Although the evidence of the informant, the victim, alleged victim is already offered. This next that it's on 8th of December.
Otherwise, you have taken steps for
Service of notice to register post. It has returned back without any note on that. Why it is returned back? It is not written on the envelope. And regarding the status of service of notice to police station and to the district magistrate, it is still away. The last order was of 26/10.
in which court it is pending.
It is additional session that's Sipsag.
Learned heard Mr. D. Das, learned counsel for the petitioner. Also heard D. Das, learned counsel for the petitioner. Also heard Miss S. H. Bora, learned additional public prosecutor. It appears from the office note dated 17/11/2023 that the service report in respect of respondent number 2 has not been received back from the officer in charge of Sipsagar police station as well as from district magistrate Sipsagar till date. I'm getting difficulty. I'll pass the order. Other matters have to be left over.